Can you please look up this site?
See if we can figure out something.
Okay, hi. Before I do anything, let's turn off the live reactions. That's what we want to do. So for those who didn't just jump over from the 15-hour stream, I think. Was it 15? Hey, Doug Lever. Welcome. There's been Judge Fleischer and Judge Boyd playing for literally 15 hours. My earphone isn't fitting today. That portal broke. Oh no! Oh no, oh no. Hopefully people realize, because it said it's having trouble connecting, and I was like, oh, please don't do this. Oh. Ooh, this thing's about to fall. Oh no. Oh no, oh no. Panic, I don't have plastic. And now I'm going to get all those comments again, like, you're really supposed to start your streams better prepared. I know, but I'm probably not going to. So we need to align our expectations accordingly. Just expect it to never be set up properly, and you will never be disappointed. So I've grabbed this case. Whew. Don't care. It seems to be the replay crew that are really like intense. Like, you talk too much. You talk too little. You haven't transformed this content. You talk too much. You're not prepared. Set up your technology. Okay, Janice. Right, so we're going to watch State v. Ricky Smith. And we are going to hope, because this court has historically shown things that I would prefer it doesn't, we're going to have to just hope that there's nothing here, because I have a call in 53 minutes.
Yeah.
Could be wrong.
So this is statute dating.
The monitor? Oh, no, that's it.
This is a power cord.
That
That's
might
a
be
monitor?
it. That's it.
Plug it to the back of the 20 volts.
No.
Is it?
I keep calling it, you take your name.
Or just working good already.
Right, it goes here.
It is.
This has gotta be at the, in the middle, right? Like this?
Yeah. That's it.
How many lawyers does it take to start a monetization?
Plugged in? Yeah, I think that works.
What would we do without these monitors?
Ah,
We just couldn't.
It is powered now.
We're set. We're good.
Think so, Josh.
Awesome.
It's powering up here.
Okay. We are on the record. Is that right? Okay. Well, let me go ahead and address one of the issues that may need clarification, although it may be fully set forth on the record from yesterday. There was a motion for continuance based on a potential conflict. I found that there was not a conflict and hence no need for a continuance. Anything else you want to put on the record with regard to that, Mr. Marks?
Mayor, I just wanted the record to reflect the petition filed by the defense to that and has been denied.
Okay. Are you ready to proceed to trial?
Yes, Your Honor.
Is the state ready to proceed to trial?
Yes, Your Honor.
Okay. Well, we will get a jury. I understand they're all here. And do you have all your witnesses lined up and ready to go?
Yes, Your Honor. There's only one, I think Mr. Officer Akerson is on the way, but other than that, I think they all are outside.
Good.
What?
I've already asked them that. Yeah, it's my first time I was in.
So here's the thing. No, I can't talk to you in this courtroom. I'll tell you why. This is gonna be.
So in Fulton, do y'all swear the witnesses or do I?
The deputy does.
Okay, the deputy does. Great, thanks.
Ready, Judge?
Okay, we're ready. Oh.
Then maybe if we got, what's his name? I didn't know. Yeah. I think West was killing us. Okay. There's a court report estimate. These are ways.
And do they call in all the witnesses at one time and swear them all at one time or do it each time they come in?
Each time they come in.
Okay. And do we give them pads and pens to write notes with?
The juror.
Okay. Is there any issue about them bringing drinks in here?
Sometimes.
Yeah, that's okay though. All right. I'm just reading all the notes that Judge McAfee has for me.
No, I don't.
Exhibit.
And I'll make one as I, real quick, and I'll email it to you. Yeah.
All right, for the jurors. All jurors present and counted for, Your Honor.
Thank you, Deputy, and thank y'all for all being here early this morning and on time in this horrible weather. We were all in place over an hour ago, making sure that we took care of preliminary matters to hopefully speed this along. There's obviously some inefficiencies with court, but we try to make it as efficient as possible. And I do appreciate y'all being here on time. And I'm going to run the case as streamlined as I can. And both counsel have been doing a good job of that so far. So hopefully we'll proceed in that way. First thing I need you to do is all stand and raise your right hand, please. This will be the trial oath that you will take as a trial juror in this case. You shall well and truly try the issue formed upon this bill of indictment, between the state of Georgia and Ricky Smith, who's charged with aggravated assault, use of a firearm by a convicted felon during the commission of a crime, and possession of a firearm during the commission of a felony, and a true verdict give according to the evidence, so help you God. Yeah, I do. Have a seat. All right. Are there any witnesses in the courtroom? I don't see any witnesses in the courtroom. I understand that the rule of sequestration is going to be invoked, so all witnesses should remain outside the courtroom except when you're personally called to testify. And all witnesses should not discuss the case with any other witnesses or parties until it is concluded. Counsel, I'll ask each of you to keep an eye out, and if you see any of your witnesses, please have them leave the courtroom. Do y'all already have pads and pens? I think I see them in your case. Y'all are allowed to take notes. That's fine. You're not required to do so. If you decide to take notes, please remember that note taking should not divert you from paying full attention to the witnesses that you will hear here at the witness stand, because you and you alone will have to establish their credibility. Your observations of the witnesses during the testimony can be vital to your determination of their believability, and the notes that you take are for you and you only. They're not to be shared with anyone until deliberations begin, and then only with your fellow jurors. You can sit in any of the seats you want to when you come back. There are no assigned seats. If you need anything while you're in the jury room, knock on the door and notify the bailiff, and he will come and attend to your needs. Please remember to wear your juror badges so that you can get in and out of the courthouse more easily, and so that people will know who you are when you're walking around. And remember, anyone associated with this case, with the exception of the deputies, is prohibited from having any contact with you whatsoever. So again, don't think they're being rude. If they're not talking to you, they're just not allowed to do that. Let's see. You need to leave your notes in the jury room, except when you're in the courtroom. At the end of the case, they will be destroyed. You will not get a transcript of the witness's testimony, so you need to either remember what they say or put notes that are going to remind you. And again, as I said, this is going to be a fairly short trial, so you're not going to have to go back days and days on to remember this. Before we begin the trial, I'm going to start covering some basic principles of criminal law, explain everyone's role, and describe how the trial will proceed. The defendant has pled not guilty to the indictment, and he denies every charge in it. The indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing a crime that violates the laws of Georgia. The charges in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charges or the not guilty plea. The defendant is presumed to be innocent until he is proved guilty. The defendant begins the trial with a presumption of innocence in his favor. And this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crimes charged. The defendant has no burden of proof at all. The burden never shifts to the defendant to prove his innocence. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now, and I will give you more detailed instructions at the end of the trial. The jury has a very important role. You must decide the facts of the case from the evidence presented and apply the law that I give you in those facts to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. As the fact finder, you are the exclusive judge of the witness's credibility, and it is your duty to believe the witnesses that you think are most believable, and to determine what testimony you will believe. Exhibits are documents, photographs, and other physical items that are admitted during trial. The object of this trial is to discover the truth. During the trial, I will admit evidence according to the rules of evidence. Those rules are designed in aid to discovering the truth and in making sure that you only consider the best and the highest evidence. The lawyers are advocates for their clients, and they have a duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during trial. They may make motions or objections if they believe the rules are not being followed. What the lawyers say in making or responding to the evidence or to the objections is not evidence. I will admit or exclude evidence according to the rules. If the lawyer makes an objection and I overrule it, that means the evidence is admitted and you may consider it. If, on the other hand, I sustain an objection, that means the evidence is excluded from the trial and you may not consider it. You should only consider the testimony and the exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it in your deliberations in arriving at your verdict. None of my decisions and nothing that I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side of the case or the other. I am only interested in seeing that this case is fairly tried and based on the laws and constitution of the state of Georgia and of the United States. Sometimes I may need to deal with the lawyers on motions or objections without you being in the courtroom, like we did this morning while y'all were back there. So I will excuse you to the jury room, and we will try to limit those interruptions, but please be patient when they happen so it will help streamline what's going further. The trial will proceed as follows. First, the attorneys may give what's called opening statements. No side is required to do this, but the opening statements are not evidence. They are simply an introduction of the evidence, a preview or an outline of what the expected evidence will be. The state goes first because they have the burden of proof. Second, evidence will be presented. Third, the attorneys will give closing arguments. They may discuss the law that applies to the case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments also is not evidence. The goal of closing argument is to persuade you to decide the case in their favor. Fourth, I will explain to you the specific law that applies in this case. I will then ask you to go to the jury room to deliberate and reach your verdict. It is important that you pay close attention during the trial. If at any time you cannot hear, see, or that you're suffering from any discomfort that distracts you, please inform me or the bailiff, and we will do what is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any time, please raise your hand and alert the bailiffs. You should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all of the evidence is presented. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the law I will explain to you. You cannot conduct, as I said yesterday, research outside of this courtroom about the case or about the people or the places that are mentioned. You may not visit the place that is mentioned, and you may not refer to books or documents that were not admitted during trial. You also may not use dictionaries or other reference materials. You may not use Google or otherwise search the internet, websites, or blogs, and you may not use any other electronic media to get information about this case. Nor should you use any of these sources to get information about legal terms or the law. I will instruct you as to those matters. Finally, you may not read or listen to any accounts of this trial that might appear in any news media, whether online, in print, or on the radio. Remember that you are the ones who have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, you may not discuss your case with anyone, including your family or friends, or let anyone discuss the case with or around you. This includes discussing or sharing information by email, texting, blogging, or any form of social media until actual deliberations begin. That is, until you have heard all the evidence, the lawyer's closing arguments, and the law that applies in this case. You must not discuss the case even amongst yourselves during the breaks until then. Now, the reason we give you all of those instructions is because guess what? People have violated them before. And when they violate them, we have to start all over again. And we don't want to start all over again. It's taken us a while to get here. And the state and the defense have invested time and resources into this. And we do not want to have to start over. So please hear everything that I've told you and follow those admonitions. Now we are ready for the lawyer to give their opening statements. Is the state ready to proceed?
Yes, sir.
All right, you may proceed.
Good morning, ladies and gentlemen. My name is Roger Bridges. I'm the Assistant District Attorney for Brooke County. Along with Paul Barfield, who's also Assistant District Attorney, who will be presenting the case today of Ricky Smith versus the state versus Ricky Smith, indictment number 22 SC 190277. Okay. On behalf of the state of Georgia and the victim in this case, Mario Langford, I'd like to thank you for your service. I know jury duty never comes at a convenient time, but without you, this process will not be possible. We're here to discuss the events that occurred on September the 14th, 2022. The events occurred at the Upper Alabama. I don't know if many of you are familiar with that. That's right across the street from the 5 Point Martyr Station. It runs between the pharmacy and the location. On that day, the defendant pointed a gun at Mr. Mario Langford on the corner of Peach Street, Alabama. He followed Mr. Langford down the street with the gun and eventually told him that he was not going to shoot him. This is Alabama Street. You will see as we go through this process, the officers will discuss how this event took place and the scene in which they saw everything happen. The encounter, as I said, happened on September the 14th, 2022. It happened on Upper Alabama Street. As we look at the when they're not working. This is Peach Street. This is Upper Alabama. We have several witnesses that have come to court to testify to show that on this date, that the defendant pointed a gun at Mr. Mario Langford. And first we will hear from Mr. Langford, who is the victim in this case. And he will give you details about what happened on that day. Let me warn you right now, Mr. Langford is homeless, and he has the elements and the conditions of being homeless. But he'll come in here his best to tell you how that defendant, Mr. Ricky Smith, pointed a gun at him for no reason and threatened to slap him and shoot him. This is Mr. Langford. We also will hear from, possibly from Mr. Beasley Benson. Mr. Benson is also homeless. Once again, same condition, same circumstances. And you will hear a little bit about where they're living and how they're living and the individuals there. They are constantly out in the street and what happened. Mr. Beasley will tell you that he saw Mr. Smith point the gun at Mr. Langford. Not only will he tell you what he saw, he also will describe the clothing that Mr. Smith was wearing that day and the gun that he pointed at Mr. Langford that day. In addition to something that's unique, the gloves that actually Mr. Smith had on when he attacked Mr. Beasley, Mr. Langford. So then we hear from Officer Ferrero, and Officer Ferrero is important because he provides us with the response of the officers on the scene. You will hear how Mr. Langford didn't wait a day, wouldn't wait hours or anything. He immediately crossed the street to the MARTA station, spoke to the Officer Ferrero and told Officer Ferrero what happened. Officer Ferrero and other officers immediately jumped into action. They pursued the defendant down the street and eventually observed him reaching his hand into a garbage can, in which they say he dropped a gun in the garbage can, and then they immediately arrested him on the spot. And the beauty part of this is all calling the officer's body cam, so you don't have to guess about it. Officer Point du Jour, he also insisted in the arrest. He didn't have body cam, but you will see him on the video making the arrest, handcuffing the defendant, and question and listen to the defendant talk about the incident, what happened. And you hear the defendant speak about several different instances of what happened, but you'll never hear him talk about what he did to Mr. Langford, though he mentions Langford by name. And finally, Detective Officer DeGurman will come in and he will do the investigation for the APD. Because what we have here is MARTA Police has a limited jurisdiction. Their jurisdiction is only limited to that of the MARTA Police. When you crossed over Alabama, you crossed over to another agency, which is the APD. Surprisingly, the APD was finally called. They came in and they responded. They spoke to the defendant several times, and you hear those conversations. And it's just a conversation that the defendant has with the officer as he tries to explain his way out of the situation, explain why he shouldn't be arrested. So we've charged him with aggravated assault, in that we say that he committed the assault of one person. In this case, it's Mario Langford, by pointing a gun directly at Mr. Langford and threatening him, causing him to have apprehensions for his life. And understand, oftentimes many people think that aggravated assault, you actually hit somebody, slap somebody. It's not the case. The actual mere threat and the fact that it puts the defendant in apprehension of immediate injury, that's all we have to establish. We also have that he's possession of a firearm by a convicted felon. You will hear that from the court that Mr. defendant has already stipulated to that, and that we will show that he possessed a firearm in this day. He had the firearm, and he should not have had that firearm because he was a convicted felon. Also, he's been charged with possession of firearm and the commission of a felony, in that he possessed the firearm when he committed the act of aggravated assault. And that's what we've established, that he possessed the firearm and he committed and does establish the charge of possession of firearm to the commission of a felony. Now, what is your duty as a juror? Pay close attention. I think you heard the judge say that it's very important. We don't actually create transcripts. We don't repeat the evidence. We give you one opportunity to hear it. Occasionally, the judge will allow you to review evidence that's been put into evidence that's available to you. For the most part, you have to go on your own regulation. We ask that you listen. And I say this for both the state and the defense. You both must listen to both of us. That's the only way that the defendant will get a fair trial and the state will actually be able to say that justice is served here for Mr. Mario Wayne. Take notes. Take plenty of notes. I'm not going to tell you my age, but I just had a birthday on Saturday, and I don't remember things the way I used to. So take notes to make sure you understand there is no transcript in this receipt. In the end, what we're asking you as jurors to look at the evidence presented by the state, and if the defense puts in the evidence, you can listen to that too. And after you listen to that evidence, decide that the defendant, Mr. Smith, on the day of September the 14th, 2022, did in fact point a gun at Mr. Langford and caused him to be in apprehension of his life. And at that point in time, he was guilty of aggravated assault. And that Mr. Smith is a convicted felon in possession of a firearm and should be convicted of possession of a firearm by a convicted felon. In addition, he possessed the gun while committing the act of aggravated assault, and he should be charged accordingly, and you find him guilty of all charges. Thank you very much.
Thank you, Mr. Bridges. Mr. Marks, would the defendant like to make an opening statement?
Yes, Your Honor.
Sorry, it's me pausing. I just quickly want to move you over to the other laptop so that I don't have to move in a not ideal time. So let's just do this.
Plenty of notes. I'm not going to tell you my age, but I just had a birthday on Saturday, and I don't remember things the way I used to. So take notes, make sure you understand there is no transcript in this receipt. In the end, what we're asking you as jurors to look at the evidence presented by the state, and if the defense puts in the evidence, you can listen to that too. And after you listen to that evidence, decide that Mr. the defendant, Mr. Smith, on the day of September the 14th, 2022, did in fact point a gun at Mr. Langford and caused him to be in apprehension of his life. And at that point in time, he was guilty of aggravated assault. And that Mr. Smith is a convicted felon in possession of a firearm and should be convicted of possession of a firearm by a convicted felon. In addition, he possessed a gun while committing the act of aggravated assault, and he should be charged accordingly, and you find him guilty of all charges. Thank you very much.
Thank you, Mr. Bridges. Mr. Marks, would the defendant like to make an opening statement?
Yes, Your Honor, may it please the court.
You may proceed.
You've heard a colorful rendition from my learned adversary, Mr. Bridges, about what my client allegedly did. But your decision in this case is not going to be based on speculation, conjecture, or anything like that. It's going to be based on one thing and one thing alone: facts. And after considering the facts in this case, there will be absolutely no question whatsoever in your minds. There's absolutely no proof that the state has showing that my client committed these crimes. And because of that, at the end of this trial, I'm going to ask you to go back in the jury room and render a verdict that speaks the truth. Not guilty, because my client is not guilty, and they can't prove otherwise.
Thank you, sir. Each state may call its first witness.
We call Mr. Mario Langford.
Just look forward to the day's testimony. See, would you please, while speaking into the mic, state and spell your first and last name for the record?
You say now?
Just say your name for the record and spell it.
Mario Langford. Is Mario Langford is Lagfid.
Okay. Thank you, sir.
Good morning, Mr. Langford.
Yes, sir.
How you doing this morning?
Pretty good, sir.
Where do you currently live?
I'm homeless.
Homeless? Okay, so where do you currently stay during most of the time?
Mostly be in the park.
Or what particular park?
Woodford Park.
Woodford Park? Okay. I'm gonna need for you to speak up because they.
Woodford Park.
I'm gonna move that back close to his mouth.
That's fine.
Slide.
Yes, sir.
And how long have you been homeless?
Most all my life.
How old are you?
I'm 36.
How far did you go in school?
I graduated from military school.
Military school. Okay. Are you Atlanta native?
Yes, sir. Yes, sir.
You lived in Atlanta all your life?
Yes.
Okay. I'm going to take you to September the 14th, 2022. Do you remember that day?
Yes, sir.
Did anything unusual happen that day to you?
I got a gun pointed at me while I was talking to the two white girls.
Can you tell us a little bit more about that in detail?
I was talking to the white girl, and he just came out of the blue and pointed out and said, "I'll shoot you."
And when you say who is that individual?
First, man, right there with the.
Let me ask you another way. Can you identify the individual who pointed the gun at you today in court?
He's right there.
And can you describe what something he has on?
Yeah, he had on all black with a black hat on the head and some red black gloves.
And when you said that, you're describing what he had on the day of the incident?
Yes.
Okay. What did he have on the day of the incident?
Okay, all black, black shirt, black pants, and some black shoes, and some red black gloves, and a black hat, and some glass on the eyes.
Glasses on his eyes. Do you see the individual that pointed the gun at you in court today?
Yes, sir.
Okay. Can you describe what that individual that you're just pointing to has on?
He got on a suit right now. A church
That
shirt on
shirt
and a tie.
church shirt and tie. What color is the tie?
It's black.
It's black. Your Honor, let the record reflect he's identified the defendant, Mr. Smith. Mr. Smith.
Record shall reflect.
What did you do after the gun was pointed at you?
I just walked to the right up by the stoveway, and he still had the gun in his hand. Was trying to. He said he gonna shoot me. I'm like, what make you want to do that?
And what kind of weapon did you have?
I ain't had nothing.
You have nothing. After that, what did you do after that?
Just wait. I'll wait right up by the stove, and then he take out walking. And then when he was down there, and then they caught him with a gun and some weed and
Okay,
stuff.
so let me back up. So you said they. Who was they?
The officer,
Okay, and how did the officers know to approach him?
because they saw him running.
Objection, Judge. Personal knowledge.
Sustained, can you rephrase?
What did you do did you have a conversation with the officers?
Yeah, I told the officer he was trying to shoot me.
Okay, and do you recall where that conversation took place?
I'm right up by the Marta train station.
Marta train station. So were you on Marta property or were you on Alabama?
I was like right up by Marta gate part of the property, right up by the brick wall.
Okay. And were you the only one out there that day?
Oh, it was like few people out there.
Okay.
Few people outside.
Okay, so after you had the conversation with the officers, what did you do?
I just stand right there and smoke my cigarette, and then I went on my own business. And then I told the officer what happened, what he did, and how he pointed at me, and how he take out running, how he take out walk.
Right. And how soon, can you tell me how soon after this happened that you talked to the officer?
It was like 3 seconds, and 1 minute. Cause when he pointed at me, I just froze up my hand up. And I'm like, yo, what's going on? He said, I'm gonna shoot you. I said, no, you don't wanna do that. Then I walked across the street. He walked with me across the street. I'm like, okay, well, you following me, man. Go your way and let me go my way. Then he still following me. I'm like, all right, man, just whatever you gonna do, man. Then he didn't do it. He just take out walking straight down the street. And then I look around, I ain't see him right now. I saw him take out running where the officer was chasing him. And then they caught him when he was sitting down on the other side of the street. And if everything out of his pocket, his gloves, take the gloves out, the gun he had, weed he had. Mm-hmm.
All right, I'm sure the defense has some questions for you, so you just be patient.
Good morning, Mr. Langford.
Good morning, sir.
I have a few questions for you, and if I ask a question that's not clear, just ask me to rephrase and I'll do so, okay?
All right, sir.
Now, on the day in question, you testified that you had an encounter with my client, Mr. Smith. Is that correct?
Yes, sir.
And to the best of your recollection, where did this encounter take place?
What about a Greyhound? What about a Mall train station? Mall train station.
Do you recall approximately what time of day the incident?
It was
took
in
place?
afternoon, close in the afternoon.
Was it closer to noon or closer to 6 o'clock, if you can recall?
Well, it was at 6 o'clock afternoon.
6 p.m.?
Yeah.
And tell the jury again what happened to the best of your recollection, sir.
I was talking to young, not that was not young. It was in their 30s and like 20. I was talking to young white ladies, and I asked them for a cigarette, and then I saw him put a gun on me. I just watched my hand, and then the two ladies were like, what's going on? And then I started walking, and he followed me right by the stowaway, by the corner store. And then he still had a gun on me. And then after that, he stopped, and take out walking and went somewhere else. And then they caught him right about this little pole and a little car.
So when you're saying that he pointed a gun at you, is that your testimony?
Yes, sir.
Was that before or after you got a cigarette?
It was before I had the cigarette.
And how much time went by between when you got the cigarette and when Mr. Smith pointed the firearm at you, if you can recall?
Well, I was talking to the two white girls, and then when he started pulling out his pocket and pointing at me, said, "I'll shoot you." Now I walked across the street, he still had it on me.
And you indicated that somebody gave you a cigarette, is that correct?
Yeah.
Do you recall who that was?
It was one of my homeboy gave me a cigarette. And then that would made me was smoking. I was smoking my cigarette, trying to relax my mind. I was shocked because I didn't even know a person gonna put a gun on me.
And was that before, when you got the cigarette, you got it from your homeboy? Is that what you said?
Yeah.
Do you know who that is? Do you know that person's name?
I really don't know most of the people's name outside. I just go around and get cigarette and then go about my business.
Now, was that before or after the gun was pulled out?
It's just before.
Okay. And did you say there were two white women with you?
Yes.
Did any of them give you a cigarette?
Nah, not like that.
Do you know the names of these two white women that you were with?
Mm-hmm.
Do you recall what you were doing with them? Were you talking? What was
I was talking to them.
Had you ever seen them before?
They just when they came up, I came up because I would ask for a cigarette, and then they ain't have it. And then I went to the other dude to get a cigarette. Then I went back to the same white girl. I used that lighter to light on my cigarette.
So is it your testimony that you got a cigarette from somebody and then you went back to one of the white women to see if you can get the cigarette lit?
A lighter.
A lighter?
To light on my cigarette.
Did one of these white women give you a lighter?
Yes, sir.
Okay. And when one of the white women gave you a lighter, was the other white woman nearby?
Yeah. She was next to her friend. Cause both of them is friends. Cause they finna go to work.
How did you know that they were friends?
Cause she told me I'm with my friend. And
So you had a conversation with them?
Yeah.
Do you recall roughly how much time that conversation lasted, if you can recall?
It ain't last a bit. It ain't even last a bit. Cause when he came over with the gun, all of them was me and the white girl, we were too scared to understand what's going on.
Did he point a gun at any of these white girls?
No, he pointed at me.
Did the white girls see him point the gun at you?
Yes.
Did they go to the police with you?
Um,
After he pulled a gun on you, do you know what the white girls did?
They stay where they at. They stay where they at. And I walk across the street to the stowaway. And he followed me to across the street to the stowaway.
When Mr. Smith followed you, was he pointing a gun at you during that time frame?
Yes.
And as far as you can tell, the two white girls saw that.
Yeah.
Were there other people nearby?
Yes.
And did they
Um,
see that too?
Yeah. Oh, it was.
I'll withdraw the question and I'll rephrase it.
Right.
You said there were other people around when Mr.
Yeah.
Smith pointed the gun at you, is
Yeah.
that correct?
Yes.
And you were walking in a particular direction while Mr. Smith was pointing the gun at you. Is that your testimony?
Mm.
And while you were walking in a particular direction, with the gun being pointed at you, were there other people nearby,
Yes. Yes.
close enough where they could see you?
Yes.
And the lighting conditions, were the lighting conditions such that they would be able to see you because it's not dark?
Your Honor, we're gonna.
No, it was in the morning. It was this
Your Honor,
morning.
we're gonna object at this time.
What's
He's causing for speculation. He doesn't know what the other people saw and what their view was. He can only tell what he saw.
I'll withdraw the question and rephrase.
Okay.
Describe the lighting conditions when Mr. Smith was pointing a gun at you while you were walking away. What were the lighting conditions like? Could you see?
I was really scared and shocked. I didn't even know why he put a gun on me.
Was it daytime or nighttime?
It was in the morning time. It was close to like afternoon, almost afternoon.
So it wasn't nighttime. It wasn't dark,
No,
correct?
No. It was just like in the afternoon.
And there were lots of people nearby, correct?
Yeah, cause all of them was sitting down and smoking
Now-
cigarette.
When Mr. Smith was following you with a gun, about how long did that take place? How much time went by before when he pointed the gun at you and when he stopped pointing the gun at you? What kind of time frame are we talking about to the best of your
It
recollection?
was okay. It was almost 4 seconds and 2 and 3 minutes when he stopped. Then he take out walking.
And when he pointed the gun at you, where did you walk towards?
I stayed where I was.
So you never walked anywhere when he
No.
pointed the gun at you?
I stayed where I walked to the stowaway when he pointed at me. And then after that, I stayed where I was. And then he just disappeared. Take out walking.
So are you saying that you walked to the store while he was pointing a gun at you?
Yeah.
And where is that store in relation to where you were talking with the two white women? If you can remember.
It's next to 5 Point right here, next to the glass, the building next to it, and the store next to the used to be like a cold store to change to they had to shut it down and build it back up.
And the time it took you to walk from where the two white women were to that store, roughly how long did it take for you to walk there, if you can remember?
It only take me like 1 second.
1 second?
Yeah.
You remember the name of that store by chance?
It's like a corner store where everybody gets cereal and when you get your pills, your medicine, and all that.
Did you actually go in the store?
No, I was right up by the store.
Next to the store?
Yeah, when he pointing at me.
And was that in the front entrance of the store by chance or somewhere else near the store?
It was right here, like right up by the side of the store, like side of the store. Before you open up the store door, it was right there.
And were there any people around when that happened, if you can recall?
Yeah, a lot of people were right there. Whatever happened, cause everybody was right there chilling and smoking that cigarette right there.
You do have a mental health condition, correct, sir?
Objection, Your Honor. Lack of foundation.
Yeah.
Hold on.
Hold on. What's your response?
I can lay the foundation, but it's door opening.
And relevance, Your Honor. What's the relevance of this?
Bailiff, we'll take the jury out. Let's address this issue outside the presence of the jury, please. All right, you want to state your objection, your full objection for the record, please?
As we stated before, and the court agreed that in order for Mr. Marks to introduce anything regarding Mr. Langford's competency, he needs to lay the foundation. And then also, what's the relevance at this point? There has been no issue brought before that his competency has anything to do with the testimony he's given today in the incident that happened on September the 14th, 2022. As I previously stated to the court, his competency did not become an issue until February 2023, which is almost 8 months, 9 months after this incident happened. Thus, it's not relevant to the date in question. In addition, as the rule goes, anybody who takes the stand is assumed competent, and you have to have some legal or some basic foundation to establish why you're trying to introduce the issue of his competency when it didn't come until after this incident occurred. So for those reasons, Your Honor, I don't think he's laid the foundation, and I don't think it's relevant to this case at all, Your Honor.
Okay, give me the date that the competency issue was ordered.
Your Honor, I apologize. I don't have it. I know it's February.
It's February 23, right?
Yes, 23, Your Honor.
That's all I needed to know. All right. Mr. Marks.
Please report, Your Honor. Two issues, foundation, second issue, relevance. I'll address.
Well, let's go to relevance first.
Your Honor, the relevance is that if the defendant has a mental health issue, that's germane to the issue concerning the degree to which, if any, it impacts his ability to perceive reality with respect to the alleged events in question. The foundation consists of the fact that the witness was subject to a mental health competency stand trial evaluation and was determined to be not competent to stand trial, and was referred to the Georgia Behavioral Department for competency restoration prior to his criminal case being dismissed.
That was 5 months after. That was 5 months after this incident occurred, though, Counselor.
Yes, Your Honor.
So,
And that's correct. That's correct.
are you going to have any evidence to support the fact that he was suffering the same condition in September of 2020?
No, Your Honor.
Well, then how do we know?
Depends on how the witness responds to that question. I don't know what mental illness he acknowledges having, and B, when it started, and C, whether he was on medication at the time of the incident in the event he had a mental illness when the incident unfolded.
I think you might be able to ask that question, the last one that you said, whether he was on medications that might have impeded his ability to perceive things. But I think until the door gets opened on mental illness, until you can establish a connection to it around the date in question, then I'm going to currently sustain the objection of the state. And you could lay a foundation, and then if properly laid, or and then establish relevance. But right now I'm going to sustain the objection and let you try another route.
May I lay the foundation by asking the defendant whether he recalls being subject to a mental health evaluation and being found not competent to stand trial while facing criminal charges?
Well, but that's 5 months after this incident.
Yes, Your Honor.
So I don't know that I'm going to let you get there. I can think of ways you might be able to get there. I'm not trying to play games, but I can't try your case for you. But I'm not saying you can't get there, but I don't think you can go straight there. I think you got to get there at the time of September 14th, 2020.
Very well. Thank you, Your Honor.
And do you want anything you want to go over before the jury comes back?
No, I'm fine. Thank you.
Okay. All right. We can bring the jury back. Okay. Right for the jury. Thank you. Thank you, ladies and gentlemen. And as I mentioned during my preliminary instructions, sometimes there are objections and sometimes we have to take this stuff outside the presence of the jury or to draw no inferences from the fact that there was an objection, and the fact that y'all stepped out. We're just trying to keep this tried in a manner that protects the rights of everyone. So you may proceed, Mr. Marks.
Mr. Langford, I have a few more questions. On the day in question, do you recall whether you had consumed any alcohol or drugs or any sort of substance abuses, controlled substances that could interfere with your ability to see what's going on accurately? In other words, had you been consuming any alcohol on the day in question?
I don't drink. I don't drink.
Okay. Had you taken any drugs on the day in question? Cocaine, marijuana, methamphetamine, anything like that?
I ain't gonna make it a lie. I smoke weed.
Were you smoking
I
pot
smoke weed and I smoke cigarette. That's the only thing I smoke.
on the day in question when this incident took place? Had you smoked any marijuana?
I ever smoked marijuana?
Had you been smoking marijuana on the day that this happened?
Nah. I just woke up and walk down looking for a cigarette.
And on the day that this took place, had you been prescribed, had you been taking any sort of medications for any health issues?
I don't take medication, sir.
Okay. Have you ever taken medications for any health issues that may impact your ability to perceive reality?
When I know, I don't know. I don't even. Only I take medication is if I got like a visitor, like bipolar schizophrenia or something like that.
You take any medications for that?
I used to, not anymore.
Okay. And when you were taking medications for that, was that before or after this incident took place, if you can recall?
I ain't never taken medication.
You never taken medication?
Nah,
No
not
further
like
questions. Thank you.
Any redirect?
No, Your Honor.
All right. May the witness be excused?
Yes, Your Honor.
All right. You may be excused. Thank you for coming, Mr. Langford.
Yes, sir.
Your next witness.
That's fine. That's the thing you do.
You swear first today's testimony will be true, nothing but truth to help you. Sorry. See? Please, I speak to the mic. Spell first and last name for record.
It means Jose Ferrer.
Good morning, Officer Farrell. Where are you currently employed at?
Marta Police Department.
And how long have you been employed there?
It's going to be 5 years on January.
Okay. Is that the only law enforcement agency you've been employed with?
That's correct.
Okay. And how do you become a MARTA police officer?
I was in the military in Puerto Rico serving, and they went to recruit, and I came to the academy and start working over here.
And how long were you in the military?
Still inside. He's gonna be 12 years on May.
2 years, me. And as your martyr, did you have any training?
Yes.
What type of training did you have?
I have academy and constantly in service and annually training.
And are you post certified?
That's correct.
Would you explain to the jury what post certification is?
Post certification is the mandatory and required certification that a police officer need to work as a police officer in the state of Georgia.
And do you have to renew that?
That's correct.
And how often do you have to renew them?
Every year.
And when's the last time you renewed yours?
On last year, November.
So you'll do again in this November this year?
That's correct.
Do you have arrest power?
I'm sorry?
Do you have arrest power?
That's correct.
And would you explain to the jury what arrest power is?
Arrest power is the power that the state give me to detain, arrest, and prosecute people, felonies or felons.
And as a martyr police officer, do you have a limited jurisdiction?
Yes, we have multiple jurisdictions, but it's within MARTA or counties where MARTA is placed.
What do you mean by that?
Everywhere that MARTA have buses or rail, we have authority. We have jurisdiction.
It's limited to those areas.
The area where the counties where MARTA is placed. Yeah.
And if something happens outside of that jurisdiction, what do you do?
We still do our job, and if it's out of MARTA, we then turn into whatever jurisdiction it is.
So
what did happen? But we still have to act within the color of law and act when something is happening.
and in your training, did you get trained on how to arrest individuals?
That's correct.
Are you trained on how to interview individuals?
Yes.
Are you trained to identify drugs?
Yes.
Okay. So if I showed you some marijuana, you'd be able to identify it?
Yeah.
Let me take you to September the 14th, 2022. Were you on duty that day?
That's correct.
And what is a daily duty for you?
At that point, when I was an officer in the line, I was assigned to patrol the 5-point area. I believe that day I was doing the plaza area of 5 Points, which is the top area.
And is that located in Fulton County?
That's correct.
Okay. And did anything unusual happen that day?
On that day,
Let me ask it a different way, because you probably have unusual things happen every day.
every day, all day.
Did you come in contact with the Mario Link?
That's affirmed.
Tell us a little bit about that contact.
So I was standing, patrolling the plaza area of the 5-point station, and Mr. Mario came across the street to me and stated that somebody pointed a gun to him.
Okay. And let me ask you another thing. At that point in time, were you equipped with a body cam?
Yes.
Can you explain to the jury what a body cam is?
It's a piece of equipment that a police officer used to provide further information on an investigation and prove that everything was conducted within the law.
You explain to me like I'm a layperson, because I didn't understand what you just said.
So it's a camera that we carry on the body to record every intervention that we have.
And is it on all the time? How does it work?
It's recording all the time, but only have audio when we turn it on.
And does it record when you turn it on? That's when it starts, or does it?
It goes for our department, it goes 2 minutes before we hit the button.
And when Mr. Langford approached you that day, did you have your body cam on?
Yes.
And did that body cam record the incident that day?
That's correct.
I'm gonna give you what's marked 6 Exhibit 1. My approach down. Sure. Do you recognize that?
I recognize my initials on it.
And what is that?
This is a disc that probably contains the video of my body cam at that day.
Is that a true, accurate copy?
Yes.
At this time, I'd like to tender Exhibit 1 for
Any objection?
No objection.
Submitted without objection.
Aaron, at this time, can I publish it on?
You may.
Is your screen showing this?
Yes, sir.
Okay, and what are we looking at here?
That's the plaza level looking at the Alabama side or street of the station where the food and pharmacy and the federal building is.
And do you recognize the individual approaching you there?
That's Mario.
I'm sorry.
That's Mario.
And who is Mario?
That's the person that came to me, the victim or person that came to me and stated that somebody pointed a weapon to him across the street.
And what did you do after Mario informed you of that?
We put it over there advising that I put it over there advising that what he was telling me and started walking that way to gather further information and investigate on the situation.
And I apologize, we're having audio technical.
I saw it. Mhm.
Okay, let's take a quick pause. Can someone get the video working over here for the defense?
Oh, is it on? Is it?
We don't really need it right now. We can see that monitor.
Okay.
At some point, it'd be helpful if this was working. I don't know which one we wish to get
Do we have an AV person that can come in and do that while we're going?
Just go out hear you. Out in the back. They can hear you from the back and tell, come up to the front.
Who is?
Mr. Ball.
Okay. Boyd, if you can hear me, can you come in here and work on some AV stuff for us, please? Thanks.
Okay.
Want to interrupt the proceedings because we can see this.
Y'all okay with the AV person coming in and handle it while we keep going? Okay.
But it's going to
See if I can get him to come in and fix it. State can proceed. Are y'all waiting on something?
No, yeah, can we ask everybody to get their mics? Mute their mics.
How do I do that?
And what did you do after you spoke to Mr. Layton?
I was walking with him towards trying to get me. Okay, I was trying for him to get me where it happened at that point on the video. So I was asking him where do he point the weapon at him.
Miss Boyd, we can't get the sound to come out. Well, that sound's not coming out.
It's echoing.
It's echoing.
Turn, read your, microphone.
Any IT experts over here? Okay, is there anything we can keep doing?
Yes, we can keep going, Your
Yeah,
Honor.
keep going.
I don't think the
That's why I
actual
come in to take care of it.
audio is important to the meeting. As soon as you just tell us,
Sir,
as soon as you tell us, okay, keep going.
keep going.
Mhm.
So what did you do after that? I'm sorry.
So I was trying, at this point of the video, I was trying for him to tell me what exactly happened, because like you asked me at the beginning, there's a jurisdiction, and at that point I was trying to figure it out, it happened on Atlanta jurisdiction or on Marta jurisdiction, to know how I was gonna act after that. Still, I was going to investigate and try to find who was the person that pointed the weapon to Mario.
And why is it that Mario can come tell you this, and you automatically respond?
It's still on our jurisdiction, and I'm still a police officer. So I'm the officer standing over there, and he can come and do the complaint to me.
So what are you doing now?
We're still walking. The same thing. Over here, I stopped, ask him again where it was that the person pointed the weapon, and asking if he is able to point at the person at that point, at that area.
And was he able to point to the location where the incident happened?
Yeah, he told me it was across the street.
And was he at that point in time, was he able to identify the individual that?
He was not in the area, but after on the video, you can see when he pointed at Mr. Smith.
So, Officer, just for the record, what is that street that Plus is on?
This is Alabama Street.
And what is this area over here?
That's across the street on Alabama Street, what we call the food and pharmacy store. At that point, I was trying for him to tell me somebody that one of the persons standing outside was the person that pointed a weapon to him.
Was he able to identify the individual that pointed?
At that point, it said that we don't have the audio because somebody said on the video that it went inside the store. That's why I opened the door and tried to go inside. But at that time, Mr. Mario is able to go across the corner and see Mr. Smith walking away, and pointed at me and told him that he's the one that pointed a weapon to me.
So Mr. Smith identified for you the individual that was that.
Mr. Mario, yeah.
Mario, sorry.
Yeah.
Langford.
Langford. He pointed at me and Mr. Smith, who is walking on this street right now, down the street, almost at the corner. And when he got to the corner, he started running towards the left. And then it's when we started running behind him, and we hit the corner. So
And do you recall what street this is?
that's Broad Street. Broad.
And just for the record, I think I asked you this already. What county is this in?
Fulton County. We're running, and as soon as that car moved, you can see Mr. Smith putting his hand inside the trash can.
Pause 1 second. Get you back up. And go forward, please. Sliding. Okay. Pause it. Before we raise this gun. I'm down here. I just not really want to take it. So who's this individual right here?
That's Mr. Smith.
Okay, and prior to him raising his hand, what did you say he did?
He was putting his hand, he had his hand inside the trash can.
Inside the trash can.
Mm-hmm.
Could you describe what Mr. Smith has on that day?
He's wearing all black and have red and black glove, which was the description of Mr. Mario when he approached me.
So Mr. Mario gave you a description of him?
Yeah, he told me when I asked him what the person was wearing, he told me he was wearing all black with red letters on the shirt and red and black gloves.
And what amount of time passed between the communication with Mario and your chase?
It was within 5 minutes. Within 5 minutes, yeah.
Could you pause for a second? Maybe not. Back a little bit, please. I apologize, and I have a volume. So who's the gentleman in the back?
That's Officer Poindure,
And who's the officer next to it?
Officer May.
Me. And who's the individual on the ground?
Mr. Smith.
Okay. Did you observe Mr. Smith dropping anything as you,
I observed him with his hand inside the trash can.
no, I'm sorry, I see two gloves on the ground.
Oh yeah, he dropped the glove as soon as I pointed the weapon at him.
And what did you do next?
I started, because we all have our weapon out, we started moving tactically, so we are not pointing the weapon to each other, just having on the load ready. And I went to the trash can to see what he was doing in the trash can. At that point, I retrieved the weapon from the trash can.
You retrieved what now, sorry?
At that point, I retrieved a black millimeter from the trash can.
A black what now?
Millimeter, a black Beretta,
Was it,
weapon. Yeah, weapon. Mhm.
was it, what, how would you describe that gun?
It was a small black millimeter, old.
Did you have any description from Mario? What if any descriptions you have from Mario? Regarding-
Mario said it was a small millimeter, a small 9mm, small weapon.
And what did you do after this?
He was placed in handcuff by Officer Poindure. We escort him to the vehicle, to the patrol vehicle, and escort him to the police precinct, Marta Police Precinct, and wait for the APD unit to show up.
At any point in time, did Mr. Smith statements to Mr. Smith?
He only, at that point, he only stated that he was just coming out of work, and he didn't do any statement in reference to pointing a weapon or anything. He just stated that he didn't know what we were talking about, and that he was coming out of work.
Did he make any statements to part of the victim, Mario?
Not that I recall.
And Your Honor, I just respectfully, once we release this off, I still at some point in time like to go back and play the audio so we hear all the audio.
Okay.
I know we don't have technical personnel, but I can hold him up or probably want to.
Is this the AV person here, the woman that came in?
Oh, no, that's one of my investigators.
Okay. Do you really need this witness back again?
No, this is the only thing I
Like,
can
we
get
have
from.
problem to Mr. Mark, but
No.
already without the witness here.
No problem.
All right, well, the witness is excused, that you probably.
Oh.
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 Sorry.
Oh.
Mark, cross-examination.
Yes.
Good morning, officer.
Good morning.
Can you spell your last name for me?
Ferrer.
And this incident, as far as you can recall, took place at approximately sometime between 2 p.m. and 2:50 p.m. Is that accurate?
I believe, yeah.
At 50 Upper Alabama Street, Atlanta, in Fulton County, is that correct?
Yeah, that's the address.
And you spoke with Mr. Langford, who told you from his perspective what took place, correct?
That's correct.
And when you spoke with Mr. Langford, was he alone?
Yes.
And approximately, how long did it take for you to speak with Mr. Langford and get what you needed to get as far as information is concerned?
I would say 1 to 2 minutes or less than that.
And based on your conversation with Mr. Langford, it was determined the alleged incident took place at the corner of Peachtree Street Southwest across the street to 50 Upper Alabama Street Southwest. Is that accurate?
Yeah, in between Peachtree Street and Broad Street. Yeah.
And what, if any, to your knowledge, surveillance cameras are in that area recording that area, if you know?
No, I would not be able to answer that question. Probably the APD unit be able to give that.
Something you know about?
Yeah, we only know about the cameras in MARTA.
And at any point in time, did you observe Mr. Smith with two white women?
When he was walking around the corner and Mr. Mario pointed, he was the person that pointed the weapon. There was two, it was one white female walking in the same direction. He just started walking faster at that point.
Did it look as if Mr. Smith and this white woman were walking together?
They were walking in the same direction, and Mr. Mario stated on video, that's his girl.
Did you see any other white women who seemed to be
No,
around? Now, approximately during this time frame, is it common for there to be a lot of people around?
yes,
And based on your recollection, were there a lot of people around on this day and between these two time zones?
it was,
2 and 2:50 p.m. Were there a lot of people around as far as you can recall?
it was a fair amount of people, yeah.
And after interviewing or speaking with Mr. Langford, did you speak with anyone else other than other officers?
I directed myself to Mr. Mario or Lanford.
Did you begin an investigation to see whether other people may have seen the alleged incident?
There were more people in the area that stated that it did happen.
Tell me what they told you, because that was
Okay.
what you're saying. But I just want to understand, how many people did you talk to?
No, I was talking directly to the victim at this time, which was my priority, and the other officers were talking with other people.
Other officers spoke with other individuals,
Mhm.
correct?
That's correct.
Other lay witnesses, is that correct?
Mhm.
And the only lay witness that you spoke with is Mr. Mario Langford, your complainant in this case, is that correct?
That's affirmed.
And as far as you can tell, to the best of your recollection, how much time transpired between when you spoke with Mr. Langford and when you saw Mr. Smith walking down the street?
It was in between 1 to 5 minutes when I finally saw him on the corner of Broad Street.
Thank you. No further questions.
Redirect. Your Honor, just briefly, you recovered a gun.
Yes, sir.
This is going to be State's Exhibit 2. Approach. No.
That's it.
Thank you.
Thank you. No objection.
Approach. This is State's Exhibit 2. Do you recognize that?
Yes, sir.
How do you recognize that?
That's the weapon I recollected from the trash can.
Is that true and accurate? Is that true and accurate, the weapon that you recovered?
That's affirmed.
Yeah, Exhibit 2 for,
Tender without objection, is that correct?
No objection.
So we're gonna do. How do you want to do it now? Was it? At the box, but I mean, do you want to do it separate or do I kind of even get? I'm sorry. I said you smart. You want it over here?
No, no, I was telling you there's gloves. It's fine.
Okay.
I can turn on the gloves.
Well, Terrell, did you recover anything else that day?
Not that I recall.
What about the gloves?
Oh, that's affirm.
And this will be State's Exhibit 3. Probably less of that. Question. Showing what's marked as Exhibit 3. You recognize these?
Those are the gloves that Mr. Smith have is in his hands.
You want to tender Exhibit 3 to the court?
Objection? No objection. Admitted without objection.
And did Mr. Smith have any drugs or anything on him?
Not that I recall.
Defense asked you about the people in the area.
Mhm.
The investigation itself. The investigation yourself, whose investigation was this going to be?
He's end up being officer for APD.
And we say ABD, what do you mean?
APD.
I know the acronym, they may not know that.
Oh, Atlanta PD, Atlanta Police Department.
So the Atlanta Police Department had jurisdiction, so they actually did an investigation of this case,
That's a firm.
and that's why you didn't speak to any witnesses out there.
Yeah, we only have the victim and at that time, the suspect. APD did the investigation further on that point.
You respond?
Okay, I think we have the sound issue fixed there.
Sorry?
I think we have the sound issue.
Okay.
fixed.
Go ahead.
With an arm?
He pointed a gun.
You say he pointed at
He
you?
pointed at me. He thought he gonna shoot me. He gonna slap me. Thought he was
Where did that happen?
I ain't trying to ball.
So what happened email stating that this 30 man wearing on black with a rifle. Something 1690. It's gonna be like we're walking towards Alabama Street.
Oh, yeah. He got the red on. Yeah, no, all black. You know, two white girls now.
You say he pointed at you? Yeah. Everybody saw it. It was a rifle? It was a 9mm. Yeah, same thing. He had all black. On the foot of pharmacy? You got the first charges? Yes. Go 11. Subject have a malt gun. It's not a rifle, and he went inside the foot of pharmacy. Where do he point that at you? Here. Urban Mount stated that he pointed at him.
No, we got enough. Hold up.
You all right? No. What's the guy? The one walking? Come on, man. We may have to drunk.
Yeah, back there.
Get down! Get down! Get on the ground! Get on the ground! Get on the ground! What I'm doing? Crossfire, watch crossfire. What I'm doing? What I'm doing? I'm low. You have a weapon on you, sir? I'm low rate. I just met my. Do you have a weapon on you? I just got off from work. Do you have a weapon on you? No. Don't lose your pockets. Don't lose your pockets. I ain't got no weapon. Go ahead. Go ahead. Go ahead. Go to the tell you what's going on. They get a wrong, they automatic. Two dudes wrong, you know what I mean? Listen, we are street and we are pretrial Martin. Also, 69 years old.
Take a seat. Take a seat. Sabrina was with her.
I can't see you. Try to find the victim with her.
Officer, it sounds like he says the victim robbed him. Somebody robbed him? Did you hear that?
No, he never told me he was. No.
And what did you do after this? Looks like you're leaving the scene.
Yeah, I'm trying to go back to find Mario. Yeah.
And, at that point in time, what did you do?
They put him on the vehicle and meet them on the precinct to start doing my procedure to put it inside the cell.
Yeah, I think that concludes my question.
Anyway, recross.
No, you're right.
I mean, this witness be excused.
Yes, Your Honor.
Okay, he's be excused. Thank you, sir. Call your next witness. Everyone, the jury doing all right?
Okay. Yeah.
Raise your right hand for me. You swear affirm to the day testimony you speak in the court will be the truth, and nothing but the truth shall help you.
Yes, sir.
Please proceed. Speaking to the one through the state, it's your first and for the record.
All right. First name is Wilkins, Wilkens. Last name is going to be Point du jour, POINT -DU -JOUR.
Officer, where are you currently employed at?
I'm currently employed at Sandy Springs Police Department
And how long have you been a police officer?
for approximately 3 years.
Could you explain to the jury what's the process to become a police officer?
Go through the academy for 11 weeks at Fulton County. And once you graduate, you get your post certification.
What is post certification?
It's the certification that allows me to arrest or give me arrest powers.
Have you had any training for to be an officer?
Yes, sir.
And what type of training have you had?
I had training at Fulton County Basic Law Enforcement.
Did you have any drug interdiction or drug identification training?
Yes.
I'm not gonna belabor the point. So I see you in the Sandy Spring uniform.
Yes, sir.
How long have you been with Sandy Spring?
I joined Sandy Springs in November 2023.
And let me take you back to September the 14th, 2022. What were you employed?
Marta Police Department.
And in what capacity were you employed with that?
I was employed as a plainclothes officer.
And what is that? Your duties as a plainclothes officer?
My job is to police and patrol the areas in regular clothing.
And did you have a particular area you were patrolling on that day?
Yes, I was patrolling the downtown metro area, aka 5 Points MARTA station.
And could you describe the area for me?
It's gonna be the MARTA station with a corner store or a pharmacy around the corner from me on 50 Upper Alabama Street.
How would you describe the demographic?
Busy. Yes.
Is there a particular type of people that hang out there?
It is a high crime area.
On the day in question, were you involved in the arrest of the defendant?
Yes, sir.
Okay, can you describe that to us?
On that day, I just got into the precinct because I started at 1 o'clock. The moment I got in, I heard Officer Ferrer put on the radio that he was out with a victim who stated that male brandished a firearm at him. And when I responded to Officer Ferrer, I made contact with him and the victim pointed out the subject walking down Upper Alabama Street. And we pursued him. He made contact. I drew my department issued sidearm, giving him live verbal commands to get on the ground. He dropped gloves, and I did see him inside a trash can. And that's when I placed him in handcuffs.
And when did you see him inside the trash can?
The moment we came around the corner, and when we was approaching him, he was in the trash can.
And I'm gonna show you the video. Could you just identify yourself on the scene?
Yes, sir.
Yo! Get down! Get down! Get on the ground! Get on the ground!
That's me right there.
On the ground!
You see yourself on video?
Yes, sir.
Can you describe where you are, what you have on?
I'm gonna be behind the suspect wearing a black T-shirt. Have my MARTA badge displayed. It's like a fanny pack across my chest with a Chicago White Sox hat, gray jeans, and black and white shoes. Right behind the subject.
No, we're streetwise there. Where you at?
Oh, that's gonna be MLK.
Okay.
Yes.
Is that in full county?
Yes, sir.
And do you see the trash can that you allegedly stepped in?
Yes, sir. It's gonna be right next to me, right next to the tree right there.
Were y'all able to retrieve anything out of the trash can?
Yes, Officer Ferrer, he did retrieve a firearm from the trash can.
What did you do with this?
Well, at the time, I put the handcuffs on him. I was placing him in the vehicle.
Did he make any statements while you were out there?
He did say he just got off of work.
Did he say anything else?
I can't recall.
No, this is a while back. Okay, I have no further questions.
No questions, thank you.
Any reason that may not be excused?
You can excuse yourself.
Are you excused, sir? Thank you.
All right.
All your name?
All right, thank you.
I'm sorry. Please. Check some these we got, but these we have to,
Face me, raise your right hand, for please. You swear affirm to the day's testimony to give the court will be the truth, and that's the truth, so help you.
yes, I do.
Take a seat. While speaking to the mic, state your first and last name for the record.
Yes. First name is Pierre. That's Pierre. Last name is Dagrin. Dagrin.
Good morning, Officer Dagger. How are you doing today?
All right, sir.
Where are you currently employed?
Atlanta Police Department.
How long have you been employed for doing?
Since I got on the street in 2014, so 10 years.
What are your duties as a, what is your position for?
Right now, I'm in the MARTA 5 Points Underground Detail. I was been there since 2018, and that's just patrolling the MARTA station and everything around it.
And are you post certified?
Yes, I am.
And can you explain to the jurors what post certifications? Can you explain to the jurors what post certifications?
Oh, yes, that's going through a 5-month academy for APD, firearms training, laws, and just general things that you have to do through the academy.
And are you trained in drug addiction identification?
Yes, I have. Through my knowledge training experience, I've had a lot of interactions with marijuana, crack. I've made many cases on crack and marijuana in that area.
Describe that area for us.
Well, it's a high crime, high drug sale, drug use area. So I've been there for about 6 years. I pretty much know the dealers by name and everybody, all the regulars. I know who does what by name and everything.
Do you know Mario Langford?
Yes, I know Mr. Langford.
How do you know Mr.?
He frequents the area. He's a real, calm guy. He doesn't cause no problems. Never had to arrest him or anything.
Also character evidence, objection.
I don't need it, Your Honor. Okay.
Yes, I know him.
Thank you. I lost my train of thoughts. This happens when you know. So you post certified, do you have arrest power?
Yes, I do.
And what does that entail?
Well, essentially, I can make the charges and arrest them, take them to jail, and bring them to you guys.
And jurisdiction wise, what is your jurisdiction?
Alabama Street, anything outside of the MARTA station, meaning, Alabama, Peachtree Street, all the streets around it.
And so the city of Atlanta.
City of Atlanta.
Let me take you September 14th, 2022. Did you respond to a aggravated assault on Alabama?
Yes, I did.
Can you tell us about
Well, it was after the fact, but I came there and they told me that someone had gotten,
I think that's the modus operandi of his officer.
He said they, so we.
well, other officers. Okay.
Do you recall the officer you spoke to that day?
Yes, Officer Ferreira is one of them.
And based on your conversation with Officer Ferreira, what did you do?
I went back, well, Officer Ferreira told me about what initially happened. I went back and talked to Mario, which is Mr. Langford, about what happened so I can get his point of view first, his own statement, all on camera. Okay, and
Sorry, that's right there. You say on camera, what do you mean?
APD issued body camera.
Agent 80 issue.
Atlanta Police Department issued body camera.
How does that work?
Well, once you get a call and if you're initiating a call between interaction between police, I turn it on. I hit it twice and it turns on. It goes back 2 minutes, but audio starts 2 minutes after.
And I'm going to show you State's Exhibit 4. And 5.
Yes, ma'am.
You recognize those?
These are copies of my body cam with my initials on top.
Okay, and you recognize them? How do you recognize them?
I signed for them.
Are they true and accurate copies of them?
Yes, from my body cam.
They're attended 4 and 5 to the evidence.
Objection? No objection. Without objection.
Permission to post, Your Honor. Officer should come up on your screen. And as you would, would you narrate for us and just tell us a little bit what's going on here?
Yes, I'm on the MARTA station platform, walking down the stairs, looking at Food Pharmacy and Express and the Federal Building 100, Alabama and 50 Upper Alabama. I'm on Alabama Street, looking down Broad as well. Walking towards the store.
And how did you know to walk towards the store?
Well, all the other officers over there, and that's the address. Well, that's where everybody was, so I figured that's where I go. And they were already calling me.
Out here, why a lot of people just say you
Mr. Mario. Mr. Mario.
and we saw.
What's the conversation there?
I asked him to explain what happened.
And can I approach?
Approach me?
Yes, sir. Just a little bit. Skip further. Yeah, no, skip further. Look. Okay, bye.
I went up on them two white girls that came up. You were walking me.
Where did he produce the gun at? Like where?
Well, went up on them two white girls standing there, and then he came right here and walked right here. And then I know the camera saw him because he was pointing at me. So I'll shoot you. I'll slap you.
So these guys were here too, right?
Yeah, that one
So
right
they
here.
should have saw it too, right?
Yeah.
Yeah. During your investigation, did you speak to other people in the area regarding the incident? Without telling me what they said,
Yes, I did.
okay? Go ahead, keep going. Do you recognize the gentleman in the wheelchair?
Yes, that's we call him Yellow. Yella.
Did you speak to him regarding this incident?
Yes, I spoke to him.
Do you know where he's at today?
He died.
He died. Do you know
Yes.
how he died?
He was laying on the floor for a couple of days, I think, from the rain and the cold. And they said he also had cancer, but it's probably natural causes.
And see the gentleman in the black?
Yes,
Did you speak to him regarding this incident?
yes, that's Mr. Beasley.
And how do you know Mr. Beasley?
He's a regular.
When you say regular, what do you mean?
He's out there every day. Every day I work, I see him.
And after you spoke to them, what did you do?
I walked off, I believe, and went back to talk to Mr. Mario again.
And just give us a second to get past these individuals. Mr. Beasley, would you consider, I'm sorry, officer, would you consider Mr. Beasley's homeless?
Yes.
And what are you doing now?
Questioning Mario about the situation.
It's not working.
He was talking to a white girl.
And what happened? Well, he was talking to a white girl, and what happened?
I was trying to light up her cigarette, and he told me, man, get away from her if I shoot you.
Okay.
And I would keep on walking, he followed me up here with a gun.
Yo, come on, man.
I was behind my bed. He can't fix that. Do like that. Do like that. I only walk past it like that. I ain't even say that to the white girl.
Well, did you say something to him? Did you say something to him?
He was still pointing. He said, I'll shoot you. I'll slap you with his gun.
What did he say?
He said, I'll slap you with his gun.
And what else did he say?
Yeah, I'll shoot you.
That's how he said it?
Yeah.
Those are the two things he said?
Yeah, I want to play Charles because, man, he gonna try to mess with you again. I ain't trying to get myself get killed out here.
So what are you doing now?
I'm about to enter the Martyr precinct to go make contact with the person they arrested.
Thank you.
So you got a watch? Yeah. You bring him in? No, he can stay. Just stay right there.
Good.
What happened?
And who's the individual sitting there?
That's the person they arrested, later identified as Mr. Smith.
Can speak up a little bit before you.
That's the person that Marta detained in reference to the incident with Mr. Mario, later identified as Mr. Smith.
You said individual in court today.
Yes, he's sitting to my left.
Can you describe something he has on?
Black tie, long sleeve shirt, bluish gray.
Now let the record reflect that the officers identified Mr. Smith.
So reflected, you plan on showing this portion here now?
Yeah.
Based on my previous ruling, I'll tell you when to stop, and
Yes,
then
sir.
if you want to make any more record outside the rest of the street.
Yes, sir.
There are just before the court, there are about 4 or 5 seconds of lag between what is on my computer screen and what is there. Do you know the timestamp? What time it's going to stop?
I don't, but it's when questions start being asked. So you'll know when there was an initial question about, is it him? And I think that's innocuous, but then when the other questions start. No, you could, that one's fine. And then there's a little bit more, and then there's more questions, and that's when it needs to stop.
Pulled the gun out on somebody. I've never seen him before. Why you putting this on me, so I ain't no problem from gun to Georgia. I've never seen that dude. You got ID on you? I ain't you got ID?
This is 6'9".
What are you trying to do here?
Trying to gather up the gun and all his belongings to identify him.
Body cam, from was any other surveillance recovered from the scene?
No, sir.
Y'all have cameras on Alabama Street?
There's actually a camera on Peachtree in Alabama, on the east side of Peachtree Street. It depends on where it was pointed.
Video regarding it.
No, sir.
Walks around here with no ID. Yeah, because I was like, did he run?
No, he was far from it. He was far. He was already far.
So he was walking south on Broadway.
So when we hit the corner, he already did the corner. When I finally told him to get it on the ground, he's with his hand inside the trash can. And then when you look inside the trash can, there's a weapon.
Is this officer testified?
Yes, officer did testify.
It's overruled. Keep going.
Or down to the
The one on the corner,
right there on the corner?
on the MLK.
Oh, on MLK. So y'all had already fouled him?
Yeah.
So y'all had to run him down?
Yeah.
Yeah, he didn't run, he just walked?
Yeah, but he wasn't crying in the middle. Yeah.
So what are you doing now?
Preparing a sheet of paper to get his name and date of birth and run him on the system. Showing me video of his body camera.
We went inside. You see the weapon too?
So here's somebody talking in the background. Who's that talking?
In the jail cell. That's the suspect. Mr. Yeah, he's the one yelling.
Is he homeless?
Yeah.
Where does he stay?
One bridge.
Which bridge?
That's Mario. Yes, it's all me going back and forth.
When did he take he took your ID?
Yeah, yesterday.
Yesterday.
Yeah, and then he still brought me again.
We'll pause it. What's the objection?
Objection, this is witness bolstering. This witness has already testified, and now we're seeing video footage of him being interviewed by the police. Now, for impeachment purposes, that's appropriate, but otherwise, this is just cumulative witness bolstering.
Okay. How much more of this is there?
Yeah, I can skip forward.
Okay, we'll skip up.
He makes the same statements he made before. He doesn't change his story.
All right, well, I'm going to overrule the objection, and as long as you skip on forward, let's keep moving.
Well, he doesn't have his name for. Do you have a middle initial? Name what he did, like.
I don't even know what's going on, because I'm like.
Don't let out of your face, away from you. Or safe houses. Okay, listen.
I'm going back to talk to Mr. Ricky in there.
Still, because I'm gonna let him know he's still going to Fulton County regardless of chest pain. Sir, shut up. Just shut up. Okay? Listen, man. This bullshit you're about to try to pull about chest pains, I'm gonna call Grady. So here's what's gonna happen. You're going to Fulton County for aggravated assault no matter how you pull this shit.
For aggravated assault for what?
Okay?
If you look on the camera, I was standing with my girlfriend when a dude approached me. Right that little corner right there. A white girl and me. He approached me and he already had robbed him and his friend. The man.
Did you elicit that conversation with him?
No.
Did you ask him anything? What happened?
No, I just, he was talking about his heart pain. I was like, you're going to go to jail. Because right now I'm going to have to go sit in Grady with him. So I was just going to tell him it's time to go so I can hurry up and get him there.
Yes, Christian.
Let me tell you something that you need to know.
So you're talking on your own free will, right? You're just telling me this. You know you have the right to remain silent on it, right?
Yeah.
And you still want to talk?
Yeah.
I'll listen. Go ahead.
The commissioner on the parks and stuff. I told him the other day when I filmed him and I put it on YouTube on my channel. That dude had robbed me over there. The white guy is the commissioner of the park. So over there with my girlfriend, if you look at the camera, I'm over there with my girlfriend. We are kissing, right? Dude came up and threatened me. All I got good.
Him, that dude right there?
Yeah, look at it.
Okay, he threatened you.
It was me, a white girl. She got my book bag. We standing on the corner, right here, right across from the store, right at the bottom right there. If you look on camera, me and her were kissing, right? And he came up and got dead in my face. You see what I'm saying? After I went raw, he wanted to do what they did there, right? So I went to the store. I told him, I said, shoot, I'm gonna go smoke that blunt. You see what I'm saying? So when I go smoke the blunt, the little black girl said, hey, they coming at you, they coming at you.
He mentioned a blunt. What's a blunt?
It's a marijuana cigarette. Where you buy the blunt, it's a cigar. It comes with the filling, with the tobacco filling. They usually gut it out and put the marijuana in it, roll it back up.
Was any marijuana recovered from?
Yes, there was marijuana recovered from.
Six, exhibit 6. Approach.
Yes, you may.
You recognize this?
Yeah. I turned that over to get put in evidence. So 2 grams was what I wrote on my report as well.
And is that the evidence you submitted to APD?
I gave it to Officer Ackerson to submit it to APD.
And that's the way you submitted?
No, I actually gave it to him in the bag. He has to go through the process of actually writing in the amount and the case number and everything like that. But it's on camera when I gave it to him.
But that is the marijuana.
Yes, the one that Mr. Ackerson put in there for me.
Exhibit to the tender, exhibit 6 into evidence.
Any objection?
No objection.
Submitted without objection.
So I walk that way. That's simple as that. But if you look on the camera, on the side of that building at the bottom down there, I came out of your station with a white girl. We chilling on the corner right there, right? And the dude that told you that approached us. If you look on the camera, so that's all I'm saying. You approached us, talk about what you gonna do to me, and I ain't gonna do shit, right? So I said, get the fuck away from me. And I ain't done that shit, so I went to the store and got him. I was gonna get me a rack, broke me a blunt. And I'm telling you the truth. So the little black girl came and said, and the police coming at you, so I walked that way. My bag is left that way with my girl. All you got to do is look on camera. You got camera.
Are you finished? Are you finished?
Yeah.
So where?
Okay, that's it.
Okay. So after you finish this aspect of the conversation with him, what did you do next?
I can't remember exactly, but I know the process is once I gave out the marijuana and to Ackerson, they went and did their thing. I had to go take out the warrants for him. I had to take those warrants and then take them to Grady and sit them in a Grady until there was someone relieved me.
And when you say warrants, what do you mean?
I had to sit in front of a judge and give him all the evidence that I had and for him to okay the warrant to take him to Fulton County on the.
Can I approach for a second?
Sure. Actually, yeah. You can just say that he's coming to. Do not say that he's all robbery. Okay.
And what charges did you take out against him?
Aggravated assault, possession of weapon by a convicted felon, marijuana possession. I think those were the 3. Yeah, I think those were the 3.
And you mentioned that you took out an aggravated assault charge. Why did you take out that charge?
From the pointing of the weapon at Mr. Mario.
Can you speak a little bit?
From pointing the weapon at Mr. Mario.
Okay, and you said the second charge was what?
Possession of a weapon by a convicted felon.
And were you able to verify whether he was a convicted felon or not?
Yes, I ran it through the ACI. I ran the background check and it came back with all that information that would allow me to make that charge.
And what did you do next?
I went through, made the charge, processed everything, got him into Grady.
At any point in time before Grady, did he seek medical attention?
I can't remember if I usually I call Grady, but I usually supposed to call Grady. I think I called Grady. They came and checked them, and then I took them to.
I'll show you your body cam when you remember that.
Yes, but I know I took him to Grady though.
Could you take a brief comfort break? I'm not sure.
Sure. Is that okay with everyone? Y'all was 5 minutes enough? All right, let's recess for 5 minutes. So I've got 2 more witnesses. Are y'all gonna call both of them? Do you know?
I believe that,
Mr. Bridges is checking right now.
Okay.
We need that. We may be done, we may call it out.
That's what I was thinking. If y'all are done, then y'all are done and we may get done before lunch, which would be good. And then I can give y'all lunch to get ready for closing. Does that sound?
That's fine. I wasn't sure how much more direct,
Yeah.
Mr. Bridges has with this witness. I don't have a lengthy process.
Well, here he is. We can, do you know how much longer direct's going to be?
Your Honor, this is the last witness I have right.
Oh, great.
How much longer is your direct examination?
Probably about 20 minutes at most.
Okay.
So I'll be finished by 1 o'clock. I think I'll be finished before
You mean by noon?
noon.
Yeah. Good. Okay. Well, let's go ahead and take a 5-minute comfort break for those of you that need anything while the jury's out that we need to address.
No, Judge.
Okay. All right. 5 minutes and let's circle back. Mhm. You got my, oh, well, we can just go out.
Here. Just regular sure. I just wanted to make sure that.
It's the hardest door to get through. You gotta keep pushing the thing. I just need to know.
What have been all?
You gentlemen doing all right today?
Yeah.
Just. I just, nice to meet you. Just to give you, a little bit of advice. But I stopped with you because when you said to him, you still ever talking, he said, yes, that was fine. You could let him talk. But then when you start asking him questions, you need to thoroughly Mirandize and go ahead and ask him. You have the right to remain silent. You know, you can say, what you say is used against you. You have the right to the lawyer. All the Mirandize. Because once you started asking you questions, that's it. Yeah, just for future reference. Mhm.
Jury instructions.
Hmm?
I've got the jury instructions to get that.
Oh, good.
And Judge Michael, he can give you a sticker
For,
for a jury charge.
okay.
Yeah, he
What-
normally tenders that to
I don't even know what you're talking about. What do you
the
mean?
jury charge.
Sends the charges back with them? Oh.
He sends one back.
Okay.
But he puts it into evidence.
Okay.
As court on.
Okay. And do you have a sticker for that?
He does.
Okay. We're gonna do it after lunch, so I'll get it done here.
that's later. Yeah, like after we go through.
Yeah. I think, keep telling me, because this is actually the first jury trial I've ever done.
So you just listen to the attorneys, the boring guys.
Oh, yeah. So I had a lawyer, Lori, tell me that she clicked into the proceeding and just recognized my voice. Someone's watching the YouTube.
Yeah. It's on.
So you go to it and be the first thing on? I said, can you go to YouTube, you trying to be the first thing on?
Mhm.
Pierre,
P-I.
E-R-R-E.
They spelled it wrong on here, right?
Should have been spelled.
They spelled. Is that?
Yeah, it's supposed to be P-I.
Okay.
It's I-double-R-E.
Thank you.
Yeah,
I
I-double-R-E.
favored, but
I-double-R-E.
I was there.
So I'll let the jury know when they get back in, that I think what the schedule will be is we expect about 20 more minutes of direct and then a short cross. And then we'll excuse them and then you're going to rest your case.
Yes, sir. I
Okay.
put the stipulation on the record.
Right.
that I will have a short cross, but I don't know how lengthy the legal record might be.
Right, okay. Well, I'm not gonna give them exact times. I just want to know, and then you're not gonna put up any evidence?
Well, I'll talk to my client about that,
Okay.
but our inclination is that my client will not take a stand testifying.
Okay, because if he does want to, I prefer to go ahead and do that too, and then give you all the lunch break to prepare for your closing.
Sure. And if he decides not to testify, I think we should need to put on the record that he knows he has a right to testify and decided to not do that.
Right. Okay, good. All right, well, we're ready.
All right, the judge. You're the president counsel, Your Honor.
Great, thank you. You can proceed.
Yeah, officer, what are we doing?
That's a Grady worker.
Grady work, what is her exactly duties?
Well, the EMS, they come and check out any subjects that may have been complaining of any kind of ache, pain, whatever, after we come in contact with them when they request medical treatment.
Where are y'all located?
Inside the Martyr Precinct, 30 Alabama Street Southwest.
We have checked his basic vital signs. If you want him to be transported,
He's good. I just need a clearance that he is good.
okay, then we'll do a tow.
That's all I need.
We're gonna do an EKG on him, and then I will send the result to
That's him yelling inside the cell.
Grady.
Yeah, well, I just need the paper here from you guys, something that says he is okay to go to jail.
Okay, yeah, I mean, we don't have a paper, but
Whatever you can.
yeah, we don't have anything. We
See
can.
how he's yelling?
Oh, yes, yes.
So that's all right.
My partner's going to our EKG monitor, so we're not ready yet.
No, I'm just gonna see if he's doing. I'm gonna tell him I need him to wait till they finish doing.
I got to use the bathroom. This is nonsense, bro. I check out from work, man.
Are you gonna
Come on,
listen?
man. Sorry, I'm with the girl.
Are you gonna listen?
Yeah, I'm listening, man.
Okay, so when they're finished doing when they're finished, because you requested this, right? So I'm gonna give it to you right now. They're not done yet. They're not.
Also, how would you describe his behavior at this point?
Response?
Your Honor, mannerisms and behavior are things the jury can take into consideration for truthfulness and honesty.
Are you asking him for his impressions of what we were actually watching right now?
Yes, sir.
I'll sustain the objection, let the jury draw their own conclusion.
Yes, sir. And what did you do after this, Your Honor? I mean, what did you do after this, officer?
Well, once they checked them out, I say I did everything and took them to Grady, and with the warrants and everything, where they would take possession of him.
And was the behavior here consistent at Grady?
Yes, it was.
We won't play that game. And then after you mentioned earlier that you took out some charges. Let's start with the first charge. You said aggravated assault.
Aggravated assault. Second would be possession of a,
Asked and answered, he was at
We actually stopped before he was finished.
and the third, oh, okay. So
I do recall him testifying to the three. Is there anything in addition to the charges that you wanted to ask?
Yes, sir.
Okay, we'll go ahead with that.
And so, you charged him with aggravated assault. What was the basis of that charge?
objection asked and answered.
Okay,
Right.
there was a weapon in that case.
the weapon that was recovered.
Okay, and why is it aggravated assault with just a weapon?
Well,
Objection asked and answered.
That was not.
I don't think that question, I agree with the previous objections, but that's overrule. Go ahead, you can answer the question.
pointing a weapon, whether it's a gun, knife, something that's going to make you believe that thing, if used against you, is going to hurt you or kill you.
And that's the basis of that.
Yes.
And you. And that we asked at this point in time, Your Honor, take judicial notice to the fact that, defense has stipulated that Mr. Smith is a community.
Right, there is a stipulation to that, isn't that correct?
That's correct, no objection.
Okay.
And so that was the basis for the gun charge.
Yes.
Thank you, officer.
And Cross?
Yes, Your Honor. Good morning, Officer Beasley. How are you?
Officer Beasley, gotcha.
So this incident allegedly took place.
Dargren.
Oh, I'm sorry. Okay. Forgive me. Not enough coffee. So this incident allegedly took place on September the 14th between 2 p.m. and 2:50 p.m. Is that fair to say roughly?
Roughly.
Okay. And we're talking about an incident location that allegedly involved the corner of Peachtree Street, southwest across the street to 50 Upper Alabama Street, southwest. Is that correct?
Yes.
Now, I want to ask you some questions about the video footage and the camera technology at that location. To your knowledge, are there cameras at that location that can record events?
Yes.
And do you know whether they were operational on this day in question?
No.
Do you know whether anyone in your department or any other department tried to secure that footage if any footage existed?
Not that I know of.
Your department does have the technological capability to secure that type of evidence. Is that correct?
Yes.
And as far as you know, that wasn't done. Is that correct?
No.
As far as you know, that wasn't done by other police departments, correct?
No.
Oh, one more question. Actually, two more questions. Number one, as far as you can recall, on the day in question and during this time frame, it was heavily populated. Is that correct?
Yes.
And next, you were familiar with homelessness in this area, correct?
Yes, I am.
A lot of homeless people are in this area, correct?
Yes.
And how long have you experienced working in this arena where you're interfacing with members in the homeless community? Roughly.
Well, in that particular area, I work there 5 days a week. So that's why I'm able to know who's who by name, because I actually interact with them.
And how many weeks, months, or years were you in that particular area?
Since 2018, I've been down there. Yes.
And you've worked in other areas dealing with homelessness. Is that fair to say?
Not, no. When I was in Zone 6, I was a patrol officer, so I was answering calls back and forth. I would deal with homeless people unless it was at a gas station or something like that. But this area is strictly my area, so I'm intimately not a lot knowledgeable about these people.
So you're intimately familiar with homelessness in this particular area?
Yes.
And as far as this particular area is concerned, is it safe to say there are a lot of homeless people in this area?
Yes.
And you interact with these homeless people?
Yes.
You talk with these homeless people?
Yes.
And you are aware of some of the challenges they may have, correct?
Yes.
And it's common, based on your experience, for there to be, for homelessness also to be associated with substance abuse, correct?
Yes.
As well as mental health issues, correct?
Yes.
As well as criminal activity, correct?
Yes.
No further questions.
Any redirect?
Officer, based on his questions, you interacted with the individuals, the homeless that day during your investigation, right?
Yes.
Did you receive any information that made you drop the charges against Mr. Smith?
No.
Any recross?
No, Your Honor, thank you.
May this witness be excused?
Yes,
Yes, Your Honor.
Your excuse, thanks. Thank you. Call your next witness.
state resident this time.
Okay. Defense have any motions to make?
Judge, if we could approach briefly.
Okay.
Okay.
That work? Okay. All right, we've got a couple of matters we're going to take care of outside of your presence. We're going to go ahead and break for lunch. There's really not a lot down here, but there are some places close by. Is an hour and 15 enough for everybody, or do you need more? Okay, is that good? All right. So it's 10 till noon. If y'all be back here no later than 5 after 1, we'll get started, and we will be wrapping up with this case today. Okay, you're excused until 5 after 1.
All right, for the jurors.
It's
Just clear.
Okay. Do you have something for the record?
Yes, Your Honor. May it please the court, at this time, since the state has rested defense moves for directed verdict on granted in favor of the defense in case 23SC190277 on the ground that failed to present sufficient evidence that will enable a rational trial of fact to find the defendant guilty of all 3 counts of this indictment, and defense rests on the evidence presented. Thank you.
Okay, any response?
Do I need to respond, Your Honor?
I don't think so, but if you'd like to.
I'll leave it in, Judge.
Okay, we're going to deny the motion. I think there was the testimony of the victim that a gun was pointed at him. As is well established in Georgia, only the testimony of one witness is needed to establish a charge. With your stipulation, I think that would wrap up count 2 and count 1 again, count 3 with the observation of the victim should they believe him. So I'll deny the motion. Anything else?
Yes, Your Honor. 2 more things, Your Honor. I just want to put on the record that I've explained to my client that he has a constitutional right to testify in his own defense. I've explained the pros and cons of that. He is elected to not testify in his defense. Is that correct, sir, Mr. Smith? You don't want to testify in this case? Thank you. And then lastly, Your Honor, we're fine with going over some jury charges before or after closing arguments with the
However the court wants to do it.
Well, that you heard me have them back at, I'd like to start back at. So you tell me, are y'all going somewhere for lunch? Do you need lunch? Do you?
Need lunch. Mr. Bridges, I can speak for him.
Okay, so do you want to convene back 15 minutes beforehand to go over jury charges? Would we need more than 15 minutes? Okay, well, let's convene back at 10 till 1. And that way, unless it's ready to go right now, we can just roll right through it. What do you, if now I'm seeing they're getting passed out, we can do it right now.
That's fine.
All right, let's just do it right now. All right, the charges on page, we've got 1 of 43. Any objection to page 1?
Nothing to defend.
Any objection to page 2?
No, Judge.
Any objection to page 3?
No, Your Honor.
Any objection to page 4?
No, Your Honor.
Page 5?
No, Your Honor.
Page 6?
No, Your Honor.
Page 7? Page 8?
No, Your Honor.
Page 9?
No, Your Honor.
Page 10?
No, Your Honor.
Page 11?
No, Your Honor.
Page 12?
No, Your Honor.
Page 13?
Go back to page 11.
Page 11?
I don't think we had any extra witness.
We did not, so we can remove that. Thank you. We were up to 13 and I heard no objection. 14,
No, Your Honor.
15,
No, Your Honor.
16,
No, Your Honor.
17,
No, Your Honor.
18,
No, Your Honor.
19,
No, Your Honor.
20,
There you are.
21,
There you are.
22,
There you are.
23,
There you are.
24,
There you are.
25, 26,
There you are.
27,
There you are.
28,
There you are.
29,
There you are.
30,
There you are.
31,
There you are.
32, 33, 34, 35,
There you are.
36,
There you are.
37, 38,
There you are.
39,
There you are.
40, 41,
There you are.
42, 43.
There you are.
Okay, anything that is not in here that needs to be given?
It might be appropriate for maybe the state of defense to draw the stipulations to whatever needs to be stipulated to be read to the jury. I don't know. It doesn't matter to me.
Right.
The state wants that for things to be clean.
Well, I think that would be appropriate. Can y'all agree on doing something and bring it back in and, about 1 o'clock, that'll give us 5 minutes to iron that out?
Yes, sir.
Okay,
It'll work.
I agree. That would be appropriate. Anything else?
No, thanks.
All right, I'll see y'all all back at 1 o'clock.
Thank you.
We're in recess.
He didn't let me out.
Oh.
He's in recess.
Yeah.
Thank you so much. He's been so good.
Attorney Mark, thank you for thinking about me. No, I don't need a break. Listen,
We just took a 5-minute break.
no, but you wouldn't, I was not in your radar when you said you didn't need nothing.
Well, you went, we took a 5-minute break, and that gave us all a chance to do our business.
5 minutes?
All right, okay. Now I need to come up with a closing line. Which I always do on the fly. You eat peanuts?
I don't like peanuts.
Oh, those are walnuts and almonds. Gosh, Tracy's really into too. You can put that on almost anything.
What about me?
Yeah, it goes well with salads,
Mhm.
you know?
I like that.
The worst case scenario in this case would be is a hung jury. Hopefully they'll just come to a verdict quick. There's one of these other. Boom. Get out of here. I don't want to keep this.
You're not gonna give me anything to eat.
I had a big breakfast.
You want me to bring you out to the breakfast?
Yeah, can you go get some? Oh, kidding. No, I'm good. I'm good. I'm
You
not.
good?
Yeah, I'm good. I'm good.
No Cheetos, no
Cheetos,
popcorn,
no.
no cookies.
Welcome to order, remain seated.
Hello, everyone. Did y'all get lunch?
Yes, Judge, we did.
Good. Well, if y'all have not been to the new Thai place down the road, I recommend it. It was good. Here, did y'all get the stipulation done?
Did, Judge, we reached those stipulations.
And I hear we've got something else we might need to take up. Okay.
Your Honor,
All right, let's go back. Let's go back on the record.
Defense rests.
Okay.
Your Honor, I do request that, the state be allowed to open this, evidence, but just for a second. According to court reporter, I did not tender the gun. I thought I did, but I did not.
You did tender the gun and it was admitted, but if you didn't, y'all allow you to do that. But I think I remember the gun being admitted without objection. Do you have?
Your Honor, we would like to tender exhibit, two of the state's evidence is the gun,
Okay.
into evidence.
Any objection?
Your Honor, we do not object to the evidence being reopened for the purpose of the state introducing this evidence, having it being admitted, even though I think it was already done, just to be on the safe side.
That's fine. Thank you. So it's admitted without objections. Does someone want to go ahead and tender the stipulation and admit that before we close?
Your Honor, wanted to bring that up to you is that we want to read the stipulation
Sure.
in front of the jury.
Sure.
And then tender it.
Okay, go ahead and read it now, though. Read it into the, let me see what it is, and then we may not make you read it twice. Make sure it's, and has this been approved by the defendant?
Yes, Your Honor.
Okay. Okay. That's fine. And you're gonna, well, why don't you go ahead and mark it as, why don't we do, y'all want to do that as a state's exhibit or court exhibit?
It doesn't matter if that's, as long as it's.
We'll go ahead and mark it as an exhibit, tender it, and it'll be admitted without objection, and then you can read it to the jury.
There are two that I don't know we want to read. Okay, so this is illegal detention. I don't know that it applies. So we need to double.
Is that the only one?
Right. This is constitutional rights.
Okay.
I don't think that applies.
Okay. Anything else?
I don't think this applies, but it would fine. I don't know that there were any part of the difficulties that were brought in.
Okay. Good question mark.
Yeah, I can't, I'm sorry.
Anything else?
I think that's it.
Okay. Gentlemen, my staff attorney has picked a few of these out that were not requested of the jury instructions and thinks they may not need to be given. Does anyone think page 20 needs to be given?
A cautionary measure I would ask to be given, even though I don't think it's necessarily relevant.
Okay, we'll give it then. How about number 22 and 23, pages 22 and 23?
Yes, I'm asking to be given as a precautionary measure as far as 22 and I'm asking for 23.
Okay, and then 24.
I believe 24 is relevant because there was some potential statements that involved potential encounter between the defendant and the complainant, so I asked to be given.
Okay, then I'll give all of them, other than number 11, which was the expert testimony, expert witness, which we talked about. All right. What's that? Okay, and then have we marked and tendered the, okay,
Move to admit. Exhibit 7.
Any objection?
Okay.
All right, it's admitted without, it's admitted.
The statement request just hold on this to reach the jury when they come back in.
That's fine. It's submitted without objection. All right, so we've had the state has closed, the defense is closed, we've reopened and reclosed. Sounds like we're ready for the jury for closing arguments. Is that correct? And you will, of course, be able to go first, or you're going to split it. Doesn't matter, but you can wait first and go last. Okay. All right, great. Bring the jury in, please.
No.
She just said, look at page 27.
No.
We know one, Judge.
Oh, really? Still not here? Okay.
Which one? Yeah. Remember where the was chasing after him? They had ended up running around the corner.
Yeah, still waiting on that one.
Okay.
And the drivers had to, I guess they had to be back at 1:15, they thought.
Oh,
But everybody back except one.
you know if it's a juror or an alternate?
I don't.
You don't know?
Do you want to recess until that jury returns?
Yeah, yeah, sure. Yeah, I mean,
I don't, I hope not.
yeah. I mean, do you need to leave or do you want to just?
I'm just. Sometimes it takes, we're not on the jury.
Well, I mean, we could stand in ease and whatever if you need to leave. I mean, I'm just gonna sit here until we'll see what happens. If you need to step out, let me know.
Okay.
Huh? They put them in a secretary holding.
Okay.
If it's
Yeah.
15 or 20 more minutes, we'll figure it out. We'll give them a little while, or maybe we know how to get a hold of them. Why don't you go ask, Mr. Derryberry, if we know how to get a hold of whichever one's not here with a telephone.
We know how to get a hold of them.
Oh, okay. We do.
Yeah, he can hear.
We
Okay.
just gotta know who it is.
All right.
You said we got him?
Yeah, he responded. I forget about that hot mic thing.
I'll be back and look at everything.
Sure. Uh-huh.
Yeah, sorry. Thank you. Come back. I'm gonna tell them, so I think.
Juror number 8 just rang the bell.
Say that again.
Juror number 8 is here.
Was that the one that was missing?
Yeah, she's going back to the jury room.
Okay. That's fine. Thank you. See which one that was. Count.
Because the bridges.
Hmm?
We caught it. Okay. We caught it. Unfortunately, after I did yeah, I caught it.
Caught what?
I put the wrong case number on my phone.
Oh, and the wrong defendants, and the wrong victim.
And wrong victim, yes, we caught off.
Yeah. I was gonna tell you after it was all over, but
That's what happens when you use stuff over and over.
Yeah.
we got everybody, when the defendant stepped out, so.
So.
How was it? Like, already had. I don't want.
Not me.
You're not the folks, sir? You are.
Wow.
You doing the closing?
I'm not doing the closing now. I think that would violate all policies, so I feel very, very ready to. I could, I think that I have a confidence. Education. Large. In August, so I'm almost on 3.
I can say it's not.
Where'd you go to law school?
Georgia State. But, I mean, they keep us in bring back. They make us suffer through this one.
Ready?
I am, yes, sir.
Oh, where's,
I think 88 Bridge stepped out.
okay.
That's fine. We waited. I'll sit there.
Oh, yeah, good point.
Yeah.
He didn't want to, I mean, he's too close to. What are you talking about all the time, 5 years away?
Yeah, 5 years, that's it. I can like climb Mount Everest.
Did you get the stickers?
Health thing,
Oh, yes, I do have stickers. Thank you.
health benefits.
Yeah.
It's got more enforcement.
And do we need the original indictment back?
Hmm?
Y'all need the original indictment back? Because I heard them say something.
I don't have the original indictment.
I thought they was gonna redact it, but I heard them talk about convicted.
Do you have the original indictment? Did y'all
I have
redact it? Oh, y'all have it.
I thought they was gonna redact
Yeah,
it.
because you're supposed to be.
Do y'all have a redacted copy of the indictment?
I believe that we were waiting to get a copy of the joint indictments that we could do the redaction.
Okay. Well, let's get it and bring it in, and then why don't you, oops, you know what? I can't pull that out because number. I need one of these printed out without page 11.
He normally reprints it and then put another sticker as two. So you have one.
Yeah.
And you have and then
Okay. So this would have been admitted too?
that would have been one.
Okay.
And then the edited would be
Would have
two.
been,
Well, give me
do you want this one?
that's fine. And we go get me one without number 11 on it.
Got question marks on some.
Like that, so that it's really.
Okay.
And then you putting on the record and for.
Okay.
Or you can use mine, mine is not posted.
I've got this one. Either way,
Okay.
whatever you want to do. I can use, if you don't want that, I'll take that. Okay.
Just put a sticker.
Are y'all going to have the redacted? Are we ready for the jury or?
Your Honor, she handed this, am I supposed to change this?
Well, y'all were going to give us one that was redacted that we could send back to the jury. If okay, can you just give it to somebody to do while we continue with closing? I mean, somebody from your office? Okay.
But do they still,
Hmm?
they still need redacted since the officer or somebody talked about him being a convicted felon?
Mhm. They're redacting the words armed robbery. That's all. So do y'all want to stand up and read the stipulation before closing argument?
Yes, just so it's
Okay.
in, for the jury.
Okay.
Sorry, it'll start right there.
Can we print you another copy?
Just.
Yes.
Yeah.
I'm having to do it again.
No, we did.
Oh,
But I remember.
the gun?
Cause he was. Where do you want me to put it?
Gotcha. No worries. That's fine. Are we good?
She's gonna print another copy.
Okay.
Because this is the one we actually joined issue with.
So all you're doing though is just having someone redact for the offense of armed robbery, correct? Is that all you're doing?
Yes.
Count two. Okay.
Printing a new jury instruction.
Okay.
There are some of them that have parentheticals, like different things that you'll have to kind of read as you go through and figure out what applies. Not a lot of them, but every now and then there's.
Right, like stipulations.
I don't know. I just know some of them had paragraphs.
Right.
She's printing out a new copy. I know. I know. They're just. I might go sit back there for jury instructions.
So you don't sleep? I used to hate, if I weren't first chair, I would leave right before jury instructions started. Oh. What did I say about not keeping your seats assigned?
You're the president counsel, Your Honor.
Great, thank you. Welcome back, ladies and gentlemen. Y'all can have a seat. We've got one stipulation to be read. I think y'all may have remembered we said there was going to be a stipulation. The state may proceed to read the stipulation to the jury.
Yes, Your Honor. This is the stipulation of parties signed between myself and the defense counsel. It reads that the parties stipulate the defendant in the above style case has previously been convicted of a felony involving the use of a firearm on April 16, 1990 in the Superior Court of Newton County, Georgia, under indictment number 90W020101.
Okay, that was admitted into evidence and that'll go back with you to the jury room and you'll consider that as if it came from the witness stand.
Your Honor, may I proceed?
You may. All right, ladies and gentlemen, we're now to the part we've closed out all the evidence in the case, and both sides have rested. And at this point, we'll do closing arguments. The state has the option to open and conclude. They've waived opening and reserved concluding. And so, Mr. Marks, you are now entitled to address the jury for your closing statement.
Thank you, make these orders. Justice. What does that word mean? Today, for example, it means that when an individual is accused of a crime, that crime or those crimes has to be proved by the state beyond a reasonable doubt. When making this outcome determinative assessment, only one thing matters: the facts, which in this case clearly show unmistakably that there's absolutely no evidence that the state has presented that proves that my client is guilty of these crimes. Fact. The lay witness testimony is riddled with inconsistencies. There was only one lay witness who testified in this case. One witness who was not a police officer, Mr. Langford, the complainant, the alleged victim, who took the stand and testified under oath, setting forth his recollection of what allegedly transpired on the day in question. Mr. Langford's testimony, with all due respect to Mr. Langford, was all over the map with all sorts of inconsistencies and contradictions, the biggest of which is the fact that he admits that he has a mental health condition. He stated that he had been taking medication.
I'm going to object, Your Honor. Stating facts that are not in the evidence.
It is an evidence.
I'm going to overrule the objection. That was the testimony, as I recall, from the defendant, that he had taken medication rather, for schizophrenia prior to, but he was not on it that day. And I'll let the jury recall what the evidence was. You're overruled. You may proceed.
He stated that he had taken medication for his mental health issue prior to the day in question. And then he also stated that he had never taken medication for that mental health condition, which is a glaring and graphic inconsistency, which I submit to you for your consideration is hugely important, particularly in a case where he's the only witness who testified. There was testimony from other police officers, but they didn't witness the incident. All they could testify about is what they heard from Mr. Langford and what they heard from my client. That's a huge inconsistency. Fact number two, there were absolutely no independent eyewitnesses. The only witness who was presented by the state is the complainant himself, Mr. Langford, and that's it. Mr. Vincent Beasley, who the state said in its opening statement would testify about what he observed, didn't testify, and nobody testified about why he didn't testify. The only one who testified is Mr. Langford himself. And this is really important, particularly in light of the fact that the context here is one where the police officers admit that at the alleged incident location, you have the ability for there to be camera surveillance And at this location, there are cameras that enable surveillance to be conducted. And yet, the police department, by its own admission through testimony, noted that no efforts were made to secure any video camera footage that may have existed with respect to the incident location. So if you don't have video footage of the incident in question, the only thing you're left with is witnesses, of which all we have is Mr. Langford. That's a huge fact. Keep in mind, this is an area which, according to the testimony presented by the state, by the prosecution, is heavily populated. Mr. Langford himself indicated in response to cross-examination, there were a lot of people around. The state's police officers conceded that point as well. This was a heavily populated area. And yet we have no witnesses. Well, we could clear that up easily if we have camera footage showing what happened or what didn't happen. But we don't have that. The police department didn't make an effort to secure that. Why? There's no testimony to the effect as to why that didn't happen. We can speculate, but we're not asked to speculate. We're asked to consider the facts and the law of this land and apply the law of this land to the facts of the case. Fact number 3, there's no forensic evidence whatsoever. My client is accused of committing this crime. He's accused of committing this crime against Mr. Langford. There's no forensic evidence linking him to that crime. And the state would say, well, why would there be? What kind of forensic evidence would you have if someone is accused of pointing a firearm at somebody else? You wouldn't normally find forensic evidence when you're limiting it to that. But what about the fact that there was a gun in a trash can? And my client had his hand in the trash can, and the police are saying that that meant that that gun was within the possession of my client. And they want you to believe that that was the gun that was previously used to commit a crime against Mr. Langford. But we have no evidence whatsoever that my client's fingerprints were on that gun. There's no evidence whatsoever presented by the state that that gun was sent to GBI for forensic testing. We don't have any of that. And there's no evidence from the state's witnesses as to why that gun wasn't secured and sent to be tested for fingerprints. Maybe the state will say, well, if he had his gloves on, you wouldn't have fingerprint evidence. So therefore, we wouldn't send it to GBI for crime testing. But there's been no testimony whatsoever that having gloves on somehow makes it so that it's impossible to get any kind of forensic evidence from a firearm, nor is there any evidence that the perpetrator, whoever that was, and we're contending it wasn't my client and they can't prove otherwise, had gloves on when he was holding a gun. And there's absolutely no evidence that there was a perpetrator to begin with, particularly in a case where you have inconsistencies when it comes to the lay witnesses, no independent witnesses, no surveillance footage, and no forensic evidence. True, my client is a convicted felon. But it's not a crime to be a convicted felon. It's a crime to be a convicted felon when you're doing other felonies, when you're committing other crimes. But they can't prove, and they haven't proved, that he committed other crimes on this day in question. They can't prove that he was in possession of a firearm while being a convicted felon. Even though he was a convicted felon, they got to prove that he was in possession of that gun. And we don't convict people simply because they're convicted felons. He's not accused of being a convicted felon. He is. We stipulated that. He's accused of possessing a firearm, which he didn't, which they can't prove, while being a convicted felon. He's accused of possessing a firearm, which he didn't, and they can't prove that he did, while committing the offense of aggravated assault, which he didn't, and they can't prove he did. You see, we live in a country that is grounded on the principle of due process. And that means, among other things, that when someone is accused of a crime, that individual, no matter who that individual is presumed innocent unless the government, the state, the prosecution can prove otherwise beyond a reasonable doubt. They've got to have evidence that's solid, that's clear. It doesn't have to be, they don't have to prove the case beyond all mathematical certainty, and they'll tell you about that. That ain't the law, but they do have to prove the case beyond a reasonable doubt. And a reasonable doubt is a doubt for which there is a reason. And I've given you 3. Each one of those reasons in and of itself is sufficient to establish clearly the absence of proof. Each of those factors shows clearly, screams clearly, reasonable doubt. And if there is a doubt for which there is a reason on your mind when it comes to these allegations, which are false against my client, then you are required to find my client not guilty. And this isn't some tactical principle in some law book on a shelf in some library or collecting dust. This principle, this due process principle, isn't a mere technicality. It defines who we are as Americans. It, I would submit to you, is the bedrock upon which our civilization rests. We don't convict people based on speculation. We don't convict people based on conjecture, and we don't convict people based on mere allegations. There's got to be proof. There's got to be proof. Now, a lot of you are younger than me, but I remember back in the day, there was this commercial. I'm 55, so I'm going back a bit, where the woman is at the counter, as an older woman, she's got that burger in her hand. And then she opens up the bun and she goes, "Where's the beef? Where's the beef?" They don't have any beef. They've got a sandwich with mayonnaise and mustard and tomatoes and lettuce. Or anything in that bread. That. They have no proof. And when you go back into that jury room, I'm going to ask you to find my client not guilty because he is not guilty and they can't prove otherwise. And I'm going to leave you with just 2 words. Just 2. Not guilty.
Mr. Bridges?
So ladies and gentlemen, we are back where we started from. Basically, as we started this is a case of the state of Georgia versus Ricky Smith. It's not the case of the state of Georgia versus Mario Langford. It's not the case of the state versus officers and what should have, could have been done. What the burden here is for the state to prove is to prove that on September the 14th, 2022, in Upper Alabama Street, Fulton County, that the defendant saw Mario Langford, followed Mario Langford down Alabama Street and pointed a gun at him. And the defendant threatened to slap and shoot Mr. Mario. You saw the video of the officers. You saw the videos from both Officer Ferrero and you saw a video from Officer Dagger. And they both showed you the scene of the incident, where it happened, I look and I continue to look, I don't see any cameras. And this was taken the day of the incident. There are no cameras. There's no camera on the MARTA station. So the imaginary video that we were supposed to recover, I don't see how we could have did it. But what we did recover is a body cam from the officers. That was very clear. And I submit to you that Mario Langford, for an individual that's supposed to have some type of mental issues, did a pretty good job coming here 2 years later and testifying pretty much exactly to the things he said back in 2022. And once again, me and Mr. Marshall, we are not young men. I can't remember what I did yesterday, let alone for 2022. But this was such a traumatic experience for Mr. Langford that he was able to come tell you how the defendant pointed a gun in his face and threatened to slap and shoot. Okay. So what are your duties as the jurors? Under the law, as jurors, you're required to listen to the law, the guidance of the court, look at the evidence, and apply the law and the evidence here. Not speculation as to what we should have did or shouldn't did, not speculation of what evidence could have been presented or what we could have done, but to actually what the evidence that is before you. That is what the law and your duty as juries require. As jurors, you're bound by the instructions by the judge. Everyone must deliberate. Any jury that refuses to deliberate, you need to let the court know so we can actually address that issue. These are the things you need to consider. When we think about, the speculation of what we should have did, what we could have presented, sympathy for the victim in this case, any prejudice against, individuals, anything of that nature that's outside the realm of what you should consider. What you should consider is the evidence that we presented to you today, the witness testimony, the photos and the videos that we presented to you, and whether the elements of the crimes were met, and sometimes motive, but the common sense factor of what you saw today. If you watch the videos and you watch Mr. Langford, he comes immediately to the officers, and you saw him speak to the officers. I can't tell you, you have to decide for yourself, but it doesn't look like he was suffering from any mental anguish, having an episode, or anything of that nature. He spoke very clearly to the officers. He explained to the officers what happened, and he actually said the exact same thing he said on the stand 2 years later, that the defendant threatened to shoot and slap him. The presumption in this falls the defendant at the beginning of the trial. The defendant is presumed innocent, and it's up to the state to prove beyond a reasonable doubt that the defendant committed these acts. That is our responsibility. The defendant has no responsibility to put any evidence. The burden of proof rests with the state, and it continues to rest with the state until we overcome that burden beyond a reasonable doubt. Now, it's not all doubt, but beyond a reasonable doubt. In finding the beyond the reasonable doubt, you must look at the weight of the evidence, use your common sense, and make inference from the evidence, not just the arbitrary and vague type of consents that, hey, they didn't present video cameras, hey, they didn't send a gun to them. That's what the evidence had to show. And it had, like the defendant say, doesn't have to be beyond a mathematical certainty. It's beyond you as people with common sense saying, based on the evidence I've heard, I need to find this defendant guilty of the aggravated assault, possession of fire by a convicted felony, and also possession of a gun during the commission of a felony. Yeah, I'm about ready to throw this clicker away. What you've heard today is what we call direct and circumstantial evidence. Direct evidence is that evidence that you hear, that you can physically touch, you physically see, and physically determine that that evidence is correct. Circumstantial evidence can be a variety of things that based on the facts and circumstances, you come to the conclusion that that is a fact established by the different circumstances that you've heard. So as we look at this, you take inference in the situation with the individual who's reaching into a garbage can to grab a, to put something in the can. And then subsequently, shortly thereafter, the police find the gun inside. Well, that's circumstantial, but you tie all the circumstances together, you get the conclusion that it's Mr. Smith that put that gun in that garbage can, and as the officer recovered it shortly thereafter. And that will be the circumstantial. As in this just example here, you look at the direct evidence, you know from looking at the window it's raining. You see the young lady at the with the raincoat on. You may not know that she is raining outside, but based on her situation, you can assume that it's from circumstantial evidence that it's raining outside. It's just common sense. Here we see the direct evidence. That's Mr. Langford taking the stand. Taking the stand, testifying that the defendant pointed a gun at him. It's Officer Ferrero finding the gun in the garbage can at the scene. Circumstantial, the officers observed the defendant putting his hand in the garbage can. They didn't actually see him put the gun in it. They say we could see that. But we're saying based on the circumstances and the totality of the circumstances, you should be able to determine that that gun belonged to Mr. Smith. As jurors, you must determine the credibility of each witness. And that's the believability, demeanor, and the interest in the outcome. You have opportunity to know all the facts and the likelihood of the story as it developed. A single witness in Georgia can corroborate and sufficient to establish a fact. In this case, our single witness would be Mr. Langford. Mr. Langford testimony alone is enough to convict Mr. Smith of not only aggravated assault, but possession of a firearm by a convicted felon, because indeed he testified that the individual pointed a gun in, and thus he was in possession of the gun. The commission of a felony, possession of a firearm to commission a felony derives from the aggravated assault. So once you prove the aggravated assault, you presume the possession of gun by commission. I don't think identity is really an issue here. We have Mr. Langford, he got a good look at the defendant. Subsequently, we have the Mr. Langford giving statements to the officers immediately thereafter. He points him out on the street. Officers follow him immediately down the street, track him down, and arrest him. They find the gun, they see him putting the gun into the garbage can, and subsequently they arrest him on the scene. And so I don't think an identification is an issue here. We know we have the right person. I don't know what the intent is. And though intent is an element of the crime, it does not have to be proven beyond all reasonable doubt. I will never know why Mr. Smith chose to put the gun to Mr. Langford's head. I have no clue. We didn't hear any testimony. Mr. Langford didn't even know, besides the fact that he was sitting there talking to the young ladies, and that Mr. Smith became upset because of that. And at some point in time, put the gun to his head, showing that he intended to shoot, telling him he needed to shoot, he was going to shoot him and slap him. When we look at the evidence of this case, it's very straightforward. We have the victim in this case, Mario Langford, testified that subsequently that the defendant pointed a gun to his head, told him he's going to slap him and shoot him. Why would Mr. Langford come up with such a story? Why would he pick this individual out, all these people in the area, and say this is the individual that stuck the gun to my head, individual that threatened to slap. You have Officer Ferrero, who Mr. Langford immediately approached after this incident happened, walked right across the street to the MARTA station, told him what happened, and Officer Ferrero, he told you, this ain't my jurisdiction. However, I'm a law enforcement. It's my job to investigate and make sure that everybody's safe in the community, so he pursued the man. And he didn't pursue it haphazardly. He stopped, found out where the individual was, identified the individual, and then pursued him. And you heard Mr. Smith say on the video, the black girl told me the police were coming, so I fled. I left my book bag up there with the white girl. He fled from the location when he heard the officers were coming. Officer Ferrero and the other officers tracked him down immediately, located him, saw him reaching into the garbage can, and immediately stopped him. And I asked Officer Ferrero, well, how did you know it was the right guy? Because Mr. Mario gave him a description. All black, glasses, black hat, even described the gun that was recovered. Circumstantial, factual, exactly. There he is, reaching into the garbage can. Just as the officer described it, wearing his exact clothes, wearing the exact clothes that Mario described him to be in, all black. Subsequently, Officer Ferrero finds the gun in the trash. This is from the body cam of Officer Ferrero. This is what he sees. Officer DuPont observes the same thing. And notice what the defendant initially says. I was at work. No one asked him, no one questioned him, no one told him that he was being arrested for assaulting Mr. Langford. He immediately gives a defense, I was at work. And I don't know if you heard the other stuff he said on the video. He started talking about somebody robbed him the night before. Never clearly saying, clearly trying to establish a defense for what he did.
Objection, Fifth Amendment.
Can you articulate the objection a little?
Yes, yeah, the state has the burden of proving the defendant's guilty, not the other way around. So to argue that somehow he has to prove that he's innocent is contrary to due process. It's a Fifth Amendment violation.
I'm stating what the defendant said. There was no basis for him to say that. He was not questioned. And I'm just repeating what he said. And he said it on video.
He said in his argument that my client gave no defense as to what he did. That's
No, I didn't say that. I said he was putting up a defense. It was,
All right.
there was nobody questioned.
I'm going to overrule the objection, but ask you to steer clear of anything that might implicate his Fifth Amendment rights.
The second officer come from the APD, because you remember, MARTA has limited jurisdiction. They can't not actually supposed to investigate these type of matters. So Officer Dargren comes later. Now, Dargren comes later, but Mr. Langford is still on the scene. And as you see Mr. Langford standing there, he actually communicates with Officer Dargren exactly what happened once again. Once again, I don't think we see any mental issues, no dementia, no schizophrenia, nothing. He just gives a conversation about what happened. He's very clear. The officer says he goes and he speaks to the individuals in this area. And he tells you, one of them was frozen to death, died, the other one's homeless. This is a difficult situation to find individuals to come to court and testify when you're there in this situation. You definitely can't bring the guy back from the dead. I'm sorry he's dead, but you saw him. He said, I talked to him, and after I talked to him, I continued to arrest this individual.
Objection, facts not in evidence, that wasn't tested.
His exact words, I continue to charge this individual. You like me to say it that way?
Well, the jury will recall what the testimony is. Overruled.
Then he got to the holding cell, and he listened to the defendant. And the defendant gave him several different explanations of what happened. But you notice once again, the officer never asked any questions. He never said what he was being arrested for. But he had an explanation of what happened on the street and what went on. How does he know what he's defending himself against? And if we speak of mental issues and challenges in life, we look at the mannerisms and the personality and the way of individual acts. And I want you to think about it clearly, what you heard from the defendant when he was in that holding cell, the way he acted, the way his behavior, the way he went on and on with the officer, screaming and hollering, even when they were giving him medical attention. Something for the officer doing his job. Now, the law is very clear in this instance. The defendant's charged with 1 count of aggravated assault. The elements of that: assaulted a person with a deadly weapon. Now you need to understand, assault is either attempting to cause violent injury or reasonable putting a person in receiving bodily injury. That is clearly, he put Mr. Langford in a position where he was in fear of receiving bodily injury. And remember what I said, 1 witness is enough to corroborate a fact. As I said, during the testimony, Mr. Langford said he pointed the gun at him, threatened him to slap and shoot him. Deadly weapon here, we saw the gun, we heard the threats, put Mr. Langford in fear. And you also heard from Officer Darren. He said that a gun is a deadly weapon that clearly why he charged with aggravated assault. Because the gun is the deadly weapon that could put a person in apprehension of their safety. Second count is possession of a firearm by a convicted felon. We have the gun in the garbage that he recovered. We have Langford saying that he possessed the gun. He stipulated to you already that he is a convicted felon. So when you look at the elements, person, firearm, convicted felon, stipulation. Count 2, he's guilty of convicted possession of firearm by a convicted felon. We heard testimony from Langford. Victim had a gun, threatened with the gun. With testimony from Officer Ferrero, covered the gun from the garbage after observing the defendant in the garbage. We have Officer Derringer saying that the defendant is a convicted felon. Also, we have the defendant himself stipulating that I'm a convicted felon.
Your Honor, I'm gonna object, facts on that. The screen says the testimony of that officer was that the officer stated that they found the defendant's gun in the trash can. They didn't state that. They found the gun in the trash can. They found my client, his hand was in the trash can. They didn't testify that that gun was my client's gun. So that's facts on evidence, and I'm objecting on that basis concerning testimony of Officer Ferrer, Ferrer.
Yeah, I'll move on.
I'm going to sustain the objection. That's my recollection as well, but the jury is instructed to remember the evidence as it came from the witness stand. Proceed.
Count 3, possession of firearms and the commission of a felony. Once again, the facts are pretty much straight here. We have a person in possession of a gun, a firearm in this case. You saw this. Gun itself that was recovered by Officer Ferrer. This is physical and forensic evidence, by the way. In the commission of a felony, the felony be here, the aggravated assault against Mr. Langford. And that would be the charges that would be the elements that we met on this stand with the witnesses we have and the evidence that we present. So When we sum this up, we look at the evidence and we look at the evidence that we have before you. And we can always say there's something more or something else we could have did, but the fact of the matter is that this is the case that we were presenting. When you heard me start this case, I talked about the fact that we were dealing with the homeless, some of the most vulnerable individuals in the community, also the individuals that are difficult to locate. Mr. Langford told you he was at this time homeless. He told you that this is an area that he frequents all the time. You saw the officer knew him, never had any trouble with him. And we have the defendant, Mr. Smith, who's in the area, who admits that he's homeless too. And this homeless person, Mr. Smith, preyed on another homeless person. Threatened him with a gun, threatened to actually stab him with a gun. Ladies and gentlemen, the state has met its burden beyond a reasonable doubt to prove that on September 14, 2022, Mr. Smith threatened Mr. Mario Langford with a gun, committing the act of aggravated assault. We have Mr. Smith, who has already admitted that he is a convicted felon and was in possession of a firearm on that day. And thus,
Actually, Judge, my client never admitted that he was in possession of a firearm on that day. That's another fact that's not in evidence.
I'm going to sustain the objection, but admonish the jury to remember the testimony. Please move on.
the defendant admitted that he was a convicted felon. We found the gun in the garbage can. After the defendant had reached his hand into the garbage can was in close vicinity. You saw him drop the gun, the gloves at that point in time, and raise his hand. Thus, it established the fact that he is guilty of the count two, of possession of firearm by a convicted felon. Count three, once again, we have the individual he's charged with aggravated assault against Mr. Langford. The state has established that on September the 14th, 2022, that indeed Mr. Smith did commit the act of aggravated assault against Mr. Langford with a gun, thus establishing the final count of commission of a felony during the commission of a felony during the count three. Let's just put that back. So as we look at the evidence, it is very clear that the jury has a choice here. We can take the testimony of the officers, we can take the body cam that we've seen, we can take the testimony of Mr. Langford, and we can determine that Mr. Smith is guilty of the charges in which the state has proven beyond a reasonable doubt. Or you could ignore it, and you could allow an individual to go free and find him not guilty. We think you should do the latter. Find Mr. Smith guilty of these charges, all charges.
Thank you, Mr. Bridges. Ladies and gentlemen, it's now my duty to instruct you as to the law that you will apply in this case. You can certainly take notes on that, but I'm going to be sending this back with you, so you don't have to. So you may just want to listen, but you're certainly welcome to take notes if you want to. But the jury charge will go back with you to the jury room, along with the indictment and the evidence that you saw tendered and admitted into the evidence. You are considering the case of the state of Georgia versus Ricky Smith. The grand jury has indicted the defendant with the offenses of aggravated assault, use of a firearm by a convicted felon during the commission of a crime, and possession of a firearm during the commission of a felony. You will be provided a copy of the indictment during your deliberations. The defendant.
Hi, friends. I'm just quickly switching back to this computer. Shame, small computer is really it's so warm from working so hard while I was focusing that it's noisy. And also I hope this mic isn't awful. Where are we? Beautiful playlist. How many minutes into this are we? 4 hours, 35, 55. Hello, where am I? Oh, that is annoying. That is so annoying. Why isn't it showing me? Okay. And my fringe is too long again. Didn't I just cut it like last week? Okay, here we are. Let's go to this. I need to disconnect this. Okay. Oh, I keep trying to put it in the wrong thing. Right. Jury's deliberating.
The term firearm includes any handgun, shotgun, or rifle. For possession of a firearm by a convicted felon, the state must prove the defendant possessed a firearm after having been convicted of a felony. For the purposes of this offense, a firearm includes a handgun, rifle, or shotgun. The law provides that criminal action shall be tried and indicted in the county in which the crime was committed. A response that said, if you want.
I think I have a jury question here. Hello, can we get some audio? Also, thanks, Evie, for putting that song in my head a bajillion days ago.
All right, for the jurors. Deal with the present, Judge.
All right, thank you, sir. Now, where's my foreman? All right, thank you, sir. I received a note that says, I assume this was written by you, that says, you have great handwriting, by the way.
Oh, my handwriting's terrible, but thank you.
Can we have something to play the video? And I wrote a response that said, if you want to see any or all of the video, I will need to bring out all of the jurors back in the courtroom and play. Do you want me to do this? And then I also added later, let the bailiff show what video you want to or need to see. That's marked as court's exhibit number 2, and I'll hand that to the court reporter to include in the record. And the bailiff came back and said to me that y'all wanted to see a portion of the video that was not actually audio played. Is that correct? Okay. So anything that was not audio played is not evidence, and therefore you cannot, the only thing that I would be authorized to show you is something that you have already heard. So you didn't hear that, so it isn't evidence. You shouldn't construe it one way or the other that it was not shown to you, but you need to just decide only on the evidence that was tendered, the witness statements, the audios that were admitted, and the evidence that was tendered. Those are the only things that you can consider. Okay, does that answer the questions?
It does.
Is there anything else that we need to address while we're out here?
When they were, when he was in the same.
I'm sorry, can you identify your name?
Oh, I apologize. I'm 10. Oh.
Okay.
But we were asking to see the, when he was in the cell, when he was giving his testimony, well, when he was stating free.
Right. Now, again, the only part that I could show, and that's if y'all want to see that again, is what we showed. When I told them to stop, you can't see anything past
Yeah,
that.
we just want to see the part that we seen.
You do want to see that part again? Okay. Do you want to cue that up? And did we bring the alternates in for that too or not? Probably.
Yes.
Will we need to do that?
Yes.
Okay. Can we go ahead and bring the alternates back in? And then also, were y'all's phones collected?
Yes.
Okay, good. Because somebody mentioned they might not have been collected. Video. Then we've asked you two alternates to join us back for that as well. So we're going to show the requested video as soon as the state has it queued up, and then we will again resume with deliberations with the 12 in the jury room and the two alternates being sequestered.
Let me give him the spiel, because I'm gonna let him know he's still going to Fulton County regardless of chest pains. Sir, shut up. Shut up. Just shut up. Okay? Listen, man. This bullshit you're about to try to pull about chest pains, I'm gonna call Greg. Because here's what's gonna happen. You're going to Fulton County for aggravated assault, no matter how you pull this shit.
For aggravated assault, what?
Okay?
If you look on the camera, I was standing with my girlfriend when a dude approached me. Right down your corner, right there. A white girl and me. He approached me, and he already had robbed me, him and his friend. The man, look, I'm not arguing. Let me tell you something that you need to know.
So you're talking on your own free will, right? You're just telling me this. You know you have the right to remain silent on it, right?
Yeah.
And you still want to talk? I'll listen. Go ahead.
The commissioner brought the parts and stuff. I told him the other day when I filmed it and I put it on YouTube on my channel. That dude had robbed me over there. The white guy is the commissioner of the parks. So over there with my girlfriend, if you look at the camera, I'm over there with my girlfriend, we are kissing, right? Dude came up and threatened me. All he got to do is
That dude right there?
Yeah, look at it.
Okay, he threatened you.
It was me, the white girl. She got my book bag. We standing on the corner, right here, right across from the store, right at the bottom right there. If you look on the camera, me and her were kissing, right? And he came up and got dead in my face. You see what I'm saying? After I've been robbed, he wanted to do what they did there, right? So I went to the store. I told him, I said, shoot, I'm gonna go smoke that blunt. You see what I'm saying? So when I go smoke the blunt, the little black girl said, hey, they coming at you. So I walk that way. That's simple as that. But if you look on the camera, on your side of that building at the bottom down there, I came out of your station with a white girl. We chilling on the corner right there, right? And the dude that told you that approached us. If you look on the camera, sir, that's all I'm saying. You approached us, talking about what he's gonna do to me, and I ain't gonna do shit, right? So I said, get the fuck away from me. And I ain't studying that shit, so I went to the store and got him. I was gonna get me a rack, roll me a blunt. And I'm telling you the truth. So the little black girl came and said, hey, the police coming at you. So I walked that way. My bag is left that way with my girl. All you got to do is look on camera. You got camera.
Are you finished?
Yeah.
So.
Okay. That's it. Anything else? All right. Y'all go ahead and head back to the jury room to begin your deliberations again, and the alternates will be sequestered. Thank you.
Okay, so what I want to say quickly before I skip ahead is today in Judge Simpson, hopefully, I have it in my calendar, is going to be the pro se SovCit guy that I was so excited to show you last week when I smashed all the glass stuff in my office by accident. So I've got all of his appearances before this ready to go. There's 2 minutes left for it to finish uploading so that we are ready for when he pops up. So I'll be keeping an eye on that for sure. They're deliberating for quite long, actually. Oh, wow. Okay, wait, they're back. Also, thank you to Lisa. I don't think she's in chat right now. But she told me I can do this with the keyboard. I had no idea.
But y'all don't care whether we stay longer or just send them home? I've already sent the two alternates home because I didn't know that they were still here. So the two alternates have gone home.
I'll defer to the state.
Your Honor, if they think it will be beneficial for them to stay longer, then I have no problem.
Okay. Well, let's bring them in and see what they say. Jurors, you mean? Okay. By name or number? Okay.
The jurors.
All right, thank you. Y'all be seated and we'll come to order. Mr. Foreman, I understand y'all are sort of at an impasse. Is that correct?
Yes, sir.
Okay, would you identify yourself by your juror number?
Juror number 16.
Thank you, sir. Now I'm at your disposal. We can keep staying. I think the trains stop running back to the lot where y'all parked for the buses at about 6:30. Do you think y'all would make some headway if y'all stayed, or do y'all want to return tomorrow?
I think there's some people that I think I heard somebody said they need to leave now. So yeah, I think we just, I think some people got some other
Obligations?
to do this evening.
You don't think staying later tonight would help resolve this?
I think we came to the consensus that,
Okay, maybe a good night's sleep on this will get us going tomorrow.
yes, sir.
All right. Well, why don't we reconvene again? Court open.
Okay, so we'll go to the next day, which is 6 minutes 33.
They're coming. Have they filled out the form? Okay. Okay.
Okay, you know what that means. Time to end the poll. 80% guilty, 20% not guilty. I'm going to vote not guilty because I didn't hear anything, and so it has not been proven to me.
Okay. All right. All right, the jurors.
What are we doing? Yeah. It don't matter.
Great. Thank you. All right. Mr. Foreperson, have you reached a verdict?
Yes, Your Honor.
Was it unanimous?
Yes, Your Honor.
Has the verdict been filled in and signed and dated by you?
Yes, Your Honor.
Please hand the verdict to the bailiff and return to your seat. Thank you. Can I have counsel come up to the bench and look at this with regard to the form? And make sure there's no issue with regard to form? Okay. Having no objections to the form of the jury, I will publish the verdict. Mr. Smith, would you please stand? In the state of Georgia versus Ricky Smith, indictment number 23 SC 190277, as to count 1, aggravated assault, we, the jury, find the defendant not guilty. As to count 2, convicted use of a firearm by a convicted felon under the commission of a crime, we, the jury, find the defendant not guilty. As to count 3, possession of a firearm during the commission of a felony, we, the jury, find the defendant not guilty. Dated this 10th day of April 2024, signed by the jury foreman. Anything from the defense? Anything from the prosecution? Okay. Ladies and gentlemen, if you'll retire back to the jury room, I will meet you back there in just a few minutes. Thank you for your service.
Well, there you go. Not guilty all round. So everybody here was wrong. Okay. So now we are gonna catch up on Thomas Styron. So this guy starts off badly, but I'm actually kind of rooting for him.
Court calls the case People versus Thomas Styron.
Oh,
I'm Stein, the living man. I'm here by special appearance.
Sorry, I should have said I need to quickly sort out a desk for my mom. She's gonna stay over here tonight because it's my birthday tomorrow. So I'm gonna be listening, but I'm gonna quickly go sort it out.
The justice matter.
I'm sorry.
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm in my papers. I'm here for justice matter.
All right, thank you. Wish to be represented by an attorney, sir?
No, I'm here, sir, juris appropriate persona.
All right. I do have to advise, so you're gonna represent, you need to stand in the middle of the podium where he's telling you to stand. Handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say, no, I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me? No. Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that.
Mr. Interpreter, you're in front of the Honorable J. Cedric Simpson out of the 14th District Court of Washington County, State of Michigan. Our number is 1.
Get somebody from security to check back there.
She's got a shirt on. So I'll take it up. So I'll deal with him. I'll take the cuffs off.
I don't know that we're gonna be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number 1 is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right, thank you.
Thank you, Your Honor.
Thank you.
Can I have your name, please?
For the record, my name is Thomas Stiver II. I'm the natural person of the living man. How we doing today, Miss Braley?
We are upright, if nothing else. So, okay. And you said your name is Thomas Styron.
The second,
The second.
and then I'm the natural person, the living man.
You. And stamp a hole. Did you? Yeah, thank you. Okay. So today is the date and time set for an arraignment. This matter. But I have a whole lot. Give me just a moment. And Mr. Styron, are you being represented by the public defender in this?
I am not. I'm representing myself.
Okay, thank you for your patience there. We had a little bit of a kerfuffle.
No
So
problem.
recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And me being a living person, I don't, my name is in proper punctuation. I don't have a all caps name, nor.
Okay, I'm going to cut you off right there. Okay.
I don't have no, sorry. I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction, subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So what you are being charged with is operating a motor vehicle without having a license on your person. So I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir, but we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
at this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pretrial for that entity? I don't. Yeah.
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pretrial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pretrial date, which is going to be June 26th.
So the documentation that I have published, recorded in with, excuse me, sorry, the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case. That's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. Is that good enough?
Whatever documentation you have,
Mhm.
bring with you to your pretrial date. That is what I am telling you, yes. So. And again, that court date, June 26th. Okay, will be June 26th at 9 a.m. before Judge Washington. The court will enter a that you are standing mute to all charges at this time.
So we're just assuming jurisdiction though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else. Am I wrong?
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat, duress, coercion of going to jail?
Your hearing is concluded, sir. You may stand up and tell the jail that you are finished.
Will not talk to me in that fashion.
In what fashion?
Case People versus Thomas Styron. Here we go.
Well, let's talk to the judge about that, right? We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're gonna go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're gonna have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding.
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. What? You got another case? You told me she was done. Here what? Oh, they're there. All right. First calls the case of the people versus tyrants. Recall. State your name.
My name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Steiner, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. This one. Recalls case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. But I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, With all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the
That will-
beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right, if you would either turn that over to the court officer so that they can provide that to Mr. Siren so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of all, watch your
beneficiary. You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all? Go figure.
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
Or this institution.
You have no evidence.
It will not
to prove that
happen.
I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
All right, the court will recall the matters of the state of Michigan versus Thomas Styron, which is 19-S00472. And Ypsilanti Township versus Thomas Styron, 24W001025.
Paul Barnett on behalf of the township.
Assistant Public Defender Donnie Lieb on behalf of Mr. Styron. Mr. Styron, can you state your name?
Can you state your name, sir?
Thomas George Styron II. Good morning.
Good morning, sir. All right. We're here in the 19S case for payment, and Mr. Styron is obviously in custody. So he has not been able to make those payments. And then as to case number 24W001025, this is a failure to display license case.
Yes, Your Honor. I'd like to request an adjournment on both these matters until a date after August 6th, which is Mr. Styron's next date in his felony matters. I'm continuing to discuss him to understand the state of his license and see if he can restore that upon his release. Additionally, he's obviously not able to make payments until he is released.
You said it was August what now?
The 6th, Your Honor.
And no objection to that, Your
Honor. All right. I can put it over to August 7th, 2024 at 9 a.m.
Thank you, Your Honor. You have a blessed day.
You too, Mr. Styron. Take care.
Thank you.
Thank you.
Well, that was no fun at all.
Court does call the case of People State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm confused on behalf of the club.
Sir, state your name, please.
I'm George Diamond, second.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the motor vehicle code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I understand everything.
Okay. And sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far, able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess I was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're saying
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you gonna say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff and they'll arrange it during the noon shift. So
gotcha.
Prior to yesterday, I was still asking, I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint and he indicated to you that it's the noon staff you're supposed to bother to try to, okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right, okay, so we'll need to then adjourn that. Have you, well, I'm gonna ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it? Or is it gonna take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also.
But you don't know total. You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jail's addressed on. So there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
okay, I got you.
Energy in that.
What do we got
that as well?
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then on the 6th.
So far, it's 2 pieces in the morning.
2, and then I got that at 1. But if I set this at 1, the expungement should set this at 2.
And as of right now, there's no expungements actually scheduled.
Got it. Okay. Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th. 2024 at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready. You know, you're.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as with this discovery and handle that. So probably done in a more timely manner. Less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendants to be here in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I am planning for information against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is when I said cook, I made it very clear. I said it meant legally to get courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my description, based on who he was looking up in his talent or the lane system, whatever it is they use in the police cruiser. Make sure they iterate that plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
Go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case. And I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week. They didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intentions of running or trying to avoid it at all. And I think my actions were sued such.
In this matter, I'm not going to at this point change your mind, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that day, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be from his court's perspective, a situation where you may pose a risk to the community. But also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I would agree with what Ms. Hughes has said, and that is that if your medical, or to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the court's trying to represent itself.
Oh no.
And in regards to the medical thing, I reported this in May. So I can flood in July before anything was ever followed up on it.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me because you have a right to do that. And I'm just gonna let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom for this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. Since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out. I believe I came and went so fast. It wasn't even obvious.
No, there were a couple of adjournments because of that. But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Styron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and potentially more that are coming. That's my whole thing on that. Okay. All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office. Okay. And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works. Thank you.
All right. Envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to everybody.
They're $1. Seriously? I got about $500 in there. Okay. Well, I'm just saying, if I can sell them for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us. Okay, Mr. Styron, I appreciate you behaving yourself this way because just listen, because you're coming in hot like you did before. I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that. And my only response to that is I've never had that happen. All the other judges have ever had one by the track. Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
she's much nicer than I am. And so she has patience. Sometimes I don't.
Fair enough.
So you got to take it as it is. All right. Thank you. You do the same.
Okay, so before I quickly hop over, we're going to have to do 1.5 speed here on Judge Andrew. One, I don't like my bangs like this. I just did that because it was in my face. Two, I think that it was his health issues that was making him a bit weird. I'm now rooting for him. It's just a hunch. I'm not a doctor, but I feel like that's the case. All right, we're gonna have to do 1.5 speed to catch up with this because this judge removes his streams the minute they end.
Stacey, you're in 41. Easy. You've also get copies of the jury instructions. I'm going to read from those now, and I've read the part of that tag already, so we're going to start at page 16. You may refer to these jury instructions during the trial, and since no one can predict the course of the trial, these instructions may change and continue throughout the trial. To cross-examine evidence and weigh each side, decide which any person's testimony. Clearly, does the witness have any bias? Yes. The other jurors, until family members, friends, and resources like dictionary, if you discover during a trial and
that has proceeding, white on December 11th. I'm not here to
go into the statement.
Thank you. 20.7 grams. Thank you very much, Your Honor. Members of the jury, during my job here, I told you that you were going to see a toxicology report that has a blood alcohol content of under 0.08. I'm not here to bury the lead. Here it is. Here's that report, and it says right there, 0.077 grams. This is People's Exhibit 1. I'm going to give that to you so you can look at it. Now you might be wondering then, you might be wondering if that report has a blood alcohol content of under 0.08, just what the heck are we doing? Well, members of the jury, you're going to hear that this case and that blood alcohol content that was measured, that measurement happened 3 hours after the defendant was pulled over. You're going to hear that on December 11th of 2022, and on Washington Street in the city of Royal Oak, the defendant, Everton Montague, was driving a white Chevy Malibu after drinking alcohol to the point that he was intoxicated, and that at that time, at the time he was driving, at the time that he was pulled over, he had a blood alcohol content over 0.08. You're going to hear that the defendant was pulled over for speeding. You're going to hear that he was pulled over because he attempted to pass another vehicle going into a bike lane. You're going to hear that that stop took place at 2:20 p.m. a.m., the early morning hours. You might be aware that's 20 minutes after bars tend to close in the city of Royal Oak. You're going to hear that the defendant was driving away from downtown. You're going to hear that when officers approached the defendant and approached his vehicle, they were immediately struck by the smell of alcohol. The defendant was slurring his words. You're going to hear that the defendant was asked to exit the vehicle. And that smell continued. The smell of alcohol was palpable even in the open air. You're going to hear that an investigation was done for operating while intoxicated. You're going to hear about a series of field sobriety tests that were done on the defendant. You're also going to hear about a series of delays that were attributable to the defendant, one after the other after the other. You're going to hear that the defendant delayed about taking a preliminary breath test. He delayed about taking a chemical test when he got to the police station. You're going to hear that there was yet another delay even when a search warrant was prepared for his blood. Delay after delay after delay to the point where by the time the blood was actually taken, it was 3 hours after the defendant was pulled over. That's why we're here, members of the jury. It's because the defendant shouldn't be able to take advantage of delay tactics in order to get around his unlawful blood alcohol content. And for these actions, he has been charged with the offense of operating while intoxicated. We talked about those elements, the judge has explained them to you, you're gonna hear about them again, but just real briefly. It's my job as the prosecutor to prove each of the 3 elements of this offense beyond a reasonable doubt. You're gonna find that the first 2 elements really are not gonna be in contention. First, that the defendant operated a motor vehicle. Second, that the defendant operated that motor vehicle on a highway or a place open to the public. That would be documented. The meat of this case has to do with element number 3, that the defendant operated the vehicle while under the influence of alcoholic liquor and or with a bodily alcohol level of 0.08 grams or more per 100 milliliters of blood, specifically milliliters of blood because it's pursuant to that measurement is done pursuant to a blood draw. So in order to prove these elements to you, I'm going to be calling 3 witnesses. The first witness is going to be the officer who made first contact with the defendant. His name is Officer Francis. He's going to take the stand and he's going to explain to you why it was that he pulled the defendant over. He's going to explain his observations of the driving. He's going to explain his observations of the defendant's demeanor. He's also going to describe the smell coming off of the defendant. The way that he smelled inside of the car, the way that he smelled outside of the car, the way that he continued to smell throughout the duration of this investigation, namely, it smelled like alcohol. He's also going to point out to you that the defendant was driving on Washington Street away from downtown Royal Oak at about 2:20 in the morning. Next, you're going to hear from Detective Pelletier. He's going to tell you that he actually had occasion to interview the defendant later that morning, is what it would be. And that the defendant made some admissions to him about going to a bar right before he was pulled over. And you're going to hear from Detective Pelletier that the defendant exhibited signs of intoxication even hours and hours later, effectively the next morning after this incident. And you're not going to hear from the toxicologist who actually analyzed the blood because that report has already been admitted in that. So who you are going to hear from is the head of the Michigan State Police Toxicology Unit. His name is Jeffrey French. And what he's going to do is talk to all of you about how the human body breaks down alcohol, what it takes for, what the mechanism is for alcohol to enter the bloodstream, and what the mechanism is and what the measurements are for blood dissipating out of the bloodstream. And he is going to explain to you what the ramifications of a 3-hour delay would be in a case like this. Members of the jury, there you have it. I'm not burying the lead. You have a toxicology report that has a blood alcohol content under a 0.08. But once you hear all of the testimony and evidence that we have today, I am going to stand here once again during my closing statement, and I am going to ask you to find the defendant guilty of operating while intoxicated. Thank you.
I'll be brief. The simple act of consuming alcohol is not illegal. Spend some time talking about that during jury selection. The simple act of entering a bar is not illegal, but for the fact that you're under the age of 21. Just because a person is drunk alcohol or smells of alcohol does not prove by itself that the person is under the influence. The test is whether the alcohol affects the mental, physical condition, their ability to essentially operate a motor vehicle. The testimony that you're going to hear is based upon observations, and I'm asking you to return verdict of not guilty, basically due to what I feel is a lack of evidence, lack of support to show that my client was under the influence. Thank you.
I think we have enough time here. You want to start testimony? You
Thank
can
you.
first witness.
Yes, Judge, at this time, people will call Officer Francis to the witness stand.
recording officer. Before you get seated, if you raise your right hand, solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes.
Have a seat. Your first and last name, please, the spelling of both for the record.
Yes, Your Honor. Good morning, everybody. I'm Officer Joseph Francis, Joseph, Francis, Francis.
Thank you. Sir, where are you employed?
With the Royal Oak Police Department.
How long have you been so employed?
With the Royal Oak Police Department going on 11 years now.
How long have you been a police officer total?
Going on 14 years now.
And can you just describe what some of your job duties are as a police officer?
I'm on road patrol. I come to work. I get my beat car assignment. I set up my car and I just patrol my beat car area, answer calls and record traffic violations or anything suspicious.
Officer, could you maybe lift that microphone up just a little bit closer? Go ahead.
Yes.
Sure. Great. Yeah, that's better for everybody. And also, if anyone can't hear me, I can move this closer too. I don't know if that's an issue. I'm pretty loud. Anyway, so Officer Francis, as part of your job duties, do you perform operating while intoxicated investigations?
Yes.
Okay. And as part of those investigations, do you perform standardized field sobriety tests?
I do.
Do you have training to perform those tests?
Yes.
Can you just describe what that training is?
My training, I'm a state instructor, so I received additional training. The initial SFST training is go to inside by MSG. They teach you about field sobriety tests, they teach you about detection. Do the SFTs, and they also have you instruct other people. I have additional training in that where I have a week training in Lansing to be certified as an SFST instructor, so I can instruct new officers and certify them as SFT as well.
Okay. How long have you been performing standard field sobriety tests for?
Since I've been with Royal Oak, my 11 years here, I've probably done 300 approximately over that investigation.
And you mentioned that you actually teach other officers how to perform.
Yes.
We'll get more into the details of those tests as we progress here. But what I'm going to do right now, officer, is I'm going to draw your attention to the date of December 11th, 2022. Were you working as a road patrol officer on that date?
Yes.
Okay. And what shift were you working?
I was on midnight shift.
On midnight shift. And what are the time parameters of that shift?
That shift is 7 p.m. to 7 a.m.
Okay. So fair to say you began on the 10th, ended on the 11th?
Yes.
Okay. On that date, on the 11th, did you pull over a white Chevy Malibu?
Yes.
Around what time did you perform that stop?
The time was about approximately 2:30 in the morning.
2:30 in the morning. Okay. And why did you effect that stop?
I was taking the radar and stationary position off the road, just reading, taking speed measurements of cars driving by. I will call my attention to the car between 50 miles per hour and 25 miles per hour. So that car, it passed, it's a one-lane road in this direction. It passed another vehicle on the road to the right using a bicycle lane. It passed the vehicle, so that drew my attention to that car.
Is that why you stopped the car for those traffic violations?
Yes.
And where did the car in fact stop?
Yes.
And where did it stop?
On Washington Street here in Royal Oak, Allen, there's a side street by Ellie Fitness.
Do you recall what direction the car was going?
Southbound.
Is that towards or away from downtown?
Away from downtown.
Away from downtown. And did you approach the vehicle?
I did.
How many people were inside the vehicle?
Just one person.
Just one person. Did you speak to that person that was inside the vehicle?
I did.
Was that person in the driver's seat?
Yes.
Do you recognize that person here in court today?
I do.
Can you just identify that person based on the article of clothing that they're wearing?
The gray suit.
Thank you, thank you. Your Honor, let the record reflect that the witness is correctly identified the defendant.
On objection to regular story class.
Now, Officer Francis, can you just explain to the jury, like, what were your initial observations? Was there anything that struck you when you approached the vehicle and made contact with Mr. Montague?
Yes, when I approached the vehicle, window was down, but my initial observation was clear plastic cups that were inside the center console, and there was a couple on the mat pocket passenger door. So they're tucked in there, and walking through the window, I can smell the odor of intoxicants emanating from inside the vehicle. Mr. Montague's eyes be bloodshot water, and his face was flushed. So my initial observation is possibly might be intoxication, intoxicated driver involved.
Okay, and let me ask you this, did you make a decision to initiate an OWI, operating while intoxicated, investigation?
Yes.
Did you make that decision at your first interaction with Mr. Montague?
After speaking with him and observing the solo cups and just the speed and the passing on the right, yes, I asked him if he was drinking while I was in the car. He said, yeah, not I'm drinking. Step out.
Just as a sort of side issue, the cups that you described, did you observe any liquid inside of them?
They were empty.
They were empty. Okay. Now, did you ask Mr. Montague to exit the vehicle?
I did.
Okay. And did he do so?
Yes.
And when he exited the vehicle, did you continue to smell alcohol in the open air?
Yes, we went to the sidewalk. I was speaking with him on the sidewalk, and coming from his breath as a person.
Okay. Could you smell it when he was speaking to you?
Yes.
Now, did you ask him about whether he had anything to drink that night?
Yes, I asked him again. He said no, he did not have anything to drink. He was leaving a friend's house at from the
Did the defendant submit to standard field sobriety tests?
Yes.
Okay. And can you just explain what, and we'll go through each of them, but which standard field sobriety tests did you perform on the defendant?
I 3 minutes in SFC training, there's 3 scientifically validated tests, and that's the horizontal gaze nystagmus. That's where you see the eyes, the walk and turn where they walk the line of the 9 steps, and then there's also the 1 leg stand where they pick up a leg and balance on a leg.
Okay. And can you just explain, are these like pass-fail tests?
They are not pass-fail. You look for clues, and each test has X amount of clues, and based on how many clues they show, you can use that to gauge your intoxication level based on studies done by NISA.
Okay. Is any one of those tests would let's say showing, you said you're looking for clues, would if the defendant is showing clues on any one of those tests, is that consistent with intoxication by alcohol?
Yes, the way the tests are broken down, for the horizontal gaze nystagmus, looking at their eyes, there's 4 clues. If you get 4 out of the 6 clues, that would indicate through the studies done that their PAC level, the high probability to be over the point weight.
Okay.
The probability of an HGN test alone is 88%. With the signs of intoxication, with take the totality of circumstances, the driving, the outward signs of intoxication, and then the clues on this test due to the studies and training.
Judge, I'm going to object. Here's he's testifying to somebody else's research. He can obviously testify that he administered the test and the results, but I believe he's going beyond that.
Well, Judge, I think he's just testifying against his own, personal knowledge about what the ramifications are of those tests. I think he's within his right. He's laid a foundation for his training. He's laid a foundation that he's familiar with that information. So I think that it's a permissible testimony.
I'm going to sustain the objection. I think it's beyond the scope
Okay. So let's talk a little bit about those field sobriety tests that you did do. So what was the first test that you administered?
The horizontal gaze and nystagmus is human test.
Okay.
And that's the eye test.
Okay. Can you just explain to the jury, number one, what is that and how do you administer it?
It's a horizontal gaze nystagmus, and what it is the way it's trained me. Alcohol affects your body, it affects your fine motor control. You can't control an eye, so muscles in the eyes will show that effect. So the horizontal gaze nystagmus, we're looking for lack of smooth pursuit is a clue. Each eye has two clues. So lack of smooth pursuit is the eye smoothly tracking the finger, or is the eye as it's following the finger, is it stuttering a little bit as it's following the finger? That's the lack of smooth pursuit. So the other clue is onset of nystagmus at maximum deviation. So maximum deviation is from what you're looking at about the shoulder, and you take it all the way out to the shoulder, and you hold it there, and you see it starts ticking. The person that the test is getting administered to, they don't know what their eye is ticking, but from the observer, you can clearly see the eye ticking, and that's an indication through, it's a training I received at maximum deviation. It indicates the BAC of formal weight range and height. I'm sorry, Your Honor. Okay.
Is that consistent with alcohol intoxication?
Yes.
Okay. And can you explain then what were the results of that test with Mr. Monty?
With that test, he had 4 of 6 clues.
Okay. And can you just explain what were the 4 that were present?
Lack of smooth pursuit in both eyes, and then nystagmus and maximum deviation in both eyes.
Okay. What were the 2 clues that were present?
The other clue is onset at 45 degrees. So once again, more alcohol in your body affects the eyes.
Judge, I'm going to object. Again, he's testifying to what I believe is somebody else's testimony, to testify observations. Yeah, so, again, I hear your response.
Well, Judge, I think that he's permitted to testify about what again, he's not really going into subject matter that he has not laid a foundation for that he would be familiar with. I mean, insofar as his hearsay objection, I don't think he's making specific reference to any out-of-court documents. He's testifying as to what his I mean, again, he testified that he is actually a state instructor for these standardized field sobriety tests. This is his personal knowledge. This is what he is familiar with by way of his experience and training. I don't think we're straying so far into an opinion that is so specialized that he's outside of the scope of what his knowledge would be as a police officer.
I disagree. I think if we get to the point of talking about interpreting what the test results are, I think we're venturing into expert testimony. So.
Well, and I understand. I'm just going to briefly put on the record that, I mean, when an officer does a field sobriety test, they necessarily have to interpret those results.
2 point. Where we're getting to talking about what is what level it's indicative of.
Okay.
We're going beyond the scope.
Okay. Understood. So I get just briefly then. So you mentioned that the nystagmus at 45 degrees, and now can you just explain what was seen there?
Yes, the nystagmus would be greater at 45 degrees, versus the shoulder. The eyes will start taking a lack of smooth pursuit, or as their gaze sticks on the finger. Like I said, to my training, I understand, Your Honor, so I'll just, it would indicate a higher alcohol level. Okay. That's what it was trained to me, and so I apologize for my stepping on your toes.
I'm not affected. So, but so it's fair to say you did not see horizontal nystagmus at 45 degrees.
45 degrees, no, I did not.
Okay. Thank you. What was the next standardized field sobriety test that you performed?
I performed the walk and turn.
Okay. Can you just explain what that test is?
So the walk and turn has two phases. It has the instructional phase where we have them with their hands at their side. They put their right foot touching their left foot. We have them hold that position so we can instruct them for the rest of the test. And during the instructional phase, there's two clues that would indicate intoxication. One is starting the test too soon, which didn't happen in this case. The other clue is you break apart, and you break that position, you break apart for balance reasons. So yes, they have one clue there. And the walking portion, after they do the walking portion, you take 9 little steps forward, and when you turn, you take a series of small steps back around, and then take 9 total steps back. So on the walking portion, there's 6 clues that you look for. So on the walking portion, the clue that I observed was an improper turn, which was a spin pivot turn without taking a series of small steps around. Those are the 2 of the 8 clues for that.
Okay. And what was the next test that you performed?
The one leg stand.
Okay.
You instruct someone. I stand at attention if you're in the military, stand, your legs there, down to the side. You pick a leg you're choosing, you lift that leg off the ground, and then you hold that position and count by 1,000, 1,001, 1,002, 1,003. It equates to 30 seconds, and then you end the test. And that test you get satisfactory without showing 2 or 4 clues in that one, and show 2 or 4.
Okay, so Mr. Montague actually did not exhibit any clues of intoxication on the one leg stand test.
Yes, correct.
Okay. Well, at that juncture then, what did you do next?
At that point, I had to take the totality of my observations, and I had to make an arrest decision for either one.
Did you ask the defendant to submit to a PDT?
I did.
Okay. Did he do so?
No.
And then after that had taken place, did you place the defendant under arrest for a while?
I did.
Now, again, you mentioned that Mr. Montague actually performed the one-legged stand test satisfactorily.
Correct.
So, can you explain to the jury why it was that you nonetheless placed him under arrest for OWI?
For subject to my training, based on totality of circumstances, the outward signs of intoxication, as in bloodshot, watery eyes, a flushed face, smelling that intoxicants coming from his breath, observed with the driving, and also the SSTs were nystagmus with the eyes, 4 and 6 clues there, 2 out of the 8 clues in the walk and turn. I felt he was intoxicated, and I arrested him for intoxication.
Now, while you were performing your investigation on the street, and I guess we should just clarify, where did you perform the field sobriety test? On the sidewalk?
Yes.
Okay. Were there any kind of delays that got in the way of you being able to do that?
Yes, he was up on the phone. He wanted advice of how we should. So, with regards to PPT, I advised him multiple times that it was his decision, not anybody else's. Still wanted that person to get their advice. So after I gave him ample time to make a decision based on his own, and that didn't happen, and he came to a crossroad where I had to make a decision, and the decision was to arrest.
Okay. How long in total were you, let's say, on the sidewalk with the defendant?
Only 25 minutes.
And after you placed him under arrest, what did you do next?
Transported to the local police department.
Okay. And what happened once you got him back to the Royal Oak Police Department?
Got him in the booking area, and I advised him these chemical test rights, which is a form that you read out of the IRS. I form. Yeah, I answered any questions he had came to it. After I read it to him, he said he would not take the offer a breath test, which is blowing the tube, the instrument, the instrument is called the master, but it's a breath test that I believe everyone can run with. He said, no, you would not take it. And he advised him, steps I would be taken, he said, no, and he said, no. Okay, you have, request a search warrant for blood to the magistrate of this court. And that's going to put him in the book or the cell just so I can complete that process. And then he said, no, I don't understand. So I gave him another opportunity. I let him read it. I re-advised him of his rights. Once again, answered any questions that he would have regarding the criminal process rights.
Okay, so let me ask you this. How many times did you actually read him this chemical pathways?
Twice.
Twice. And to be clear, did he say no at first?
Yes.
Okay. Then after you read it the second time, it sounds like he said yes.
Yes.
So what did you do after that?
After that, you have a 15-minute observation period where the person's under observation. You check their mouth, there's no foreign substances through the mouth. The 15-minute observation period is let's make sure that nothing's approaching the mouth, nothing's in the mouth. If there's anything residual in the mouth, after 15 minutes.
Okay, and that was going to be my next question. What sort of a test did you intend to administer on the defendant?
The blood test.
The blood test. Was there a name for that device?
It's a Dagmaster.
Dagmaster. Okay. Is it functionally similar to like a breathalyzer?
Yes.
Okay. Now, let me ask you this. From the point in time that he actually was arrested to the point in time when he was beginning the process of administering the Dagmaster test, how much time has elapsed?
The rest was 2:50-ish in the morning. Read his rights, I believe, refusal about 3:10 to 9 in the morning. A half hour, 40 minutes, 45 minutes gone by.
Okay.
Reading the form, the initial no, to read the form, to the yes.
Okay. And describe what happened when you were administering the Dagmaster test.
I informed Mr. Montague that it is a sensitive instrument. There's an airflow sensor from the tube, it senses airflow into it, and once the airflow was in there, there's a beep, it's a solid, steady beep, it goes beep, when there's air going to the instrument. When air stopped going to the instrument, the beeping stops to signify there's no air going in the instrument. If you do stop in the middle of a breath sample, you have to then start the whole breath sample over. It doesn't store the breath sample to add to it. It wants one solid breath sample.
Were you able to obtain a valid breath sample?
I was not.
Okay, why not?
I showed them how to do it. I explained the process. It's a nice steady breath. You don't have to overpower it. Just nice and steady. You'll take the breath. And when it came time to actually provide the sample, it'd be a partial sample. It wouldn't be a full sample. It would stop. And advise them to step back. And get your breath. You're just going to run a whole breath sample. He said he understood that. And when it was time to provide a breath, he provided a partial breath again and stop, and that process would continue. I gave him multiple attempts to do that.
Okay. And to be clear, I mean, how many, in your experience when you're administering the Dagmaster test, how many attempts does it take to get a valid sample?
Only a couple of back, 3 on one, and after you the breath, the sensor and the breath flow, you show them how to provide a sample nice and steady.
Okay. So after you were unable to get a valid sample, what did you do next?
Property, lockable property, you put him in a cell, so I can complete a search warrant for his work.
And were you able to obtain that search warrant?
Yes, I was.
Okay. And was the search warrant to have the blood drawn?
Yes.
Okay. And how was that to be done?
So once the search warrant is signed, we have to serve the search warrant, we call the local fire department to our booking area, and they're the ones that draw the blood. In this case, when they came to draw blood, they have their series of questions they have to ask. And you asked their shellfish allergy, which you said you did have a shellfish allergy. The federal department cannot draw blood when someone has that type of allergy. And after that, and you recant that you did not have a shellfish allergy. But once with that allergy, the fire department no longer can draw the blood, so then we have transported to Omaha Hospital, Mascola Hospital, here.
Let me ask about that shellfish. Do you know why they can't draw blood with a shellfish allergy?
I don't know.
You don't know. Okay, now, when you transported Mr. Montague to Beaumont Hospital, were you able to obtain, was the blood sample able to be obtained?
Yes.
And what time were those samples obtained?
Like, just a little bit after 5 a.m.
Okay. At this point, how long are we? At the time that the blood is drawn at the hospital, how long are we after the initial stop?
The stop was 2:30, blood draw was 5:10-ish. So
After the defendant was arrested, did he have any ability to drink alcohol?
No.
Thank you. I have nothing further.
Mr. Gagnon, cross. Officer indicated the stop initially occurred a little after 2:30, that time frame.
Yes, about that time.
And when you first made contact with Mr. Montague, was your vehicle stationary?
Yes.
You were positioned somewhere close to LA Fitness, I presume?
Yes, I'm on Washington Street.
The investigation into Mr. Montague eventually took place in front of the back part of LA Fitness, is that fair?
Yes.
Where were you then positioned when you first saw his vehicle?
North of that location, in the Hudson, Harrison area, Washington.
Okay, so you're probably what, maybe a block or two away?
Yes.
And you were purposely looking for vehicles otherwise violating the motor vehicle code?
Yes.
And you indicated your attention was drawn to him for what you described as speed, is that fair?
Yes.
And that stretch of road, the speed limit is what, 25?
Yes.
And you indicated you estimated his speed to be well over 45, 50?
55 million out of the area.
Okay, and that was per, then you said you used your radar?
Yes.
Okay. And you said there's also allegations that he had passed another vehicle using a bike lane?
Yes.
Describe the traffic at that time of night.
Or it was light, usually it picks up during that time frame to where I see downtown is closing.
Okay, you say it picks up, I mean, are we talking stop and go traffic or?
No, that's not.
You recall this evening then, how many other cars were in the area? Prior to stopping Mr. Montague, did you stop any other vehicles?
Prior, I had to look at how long, but not remember.
You arrest anybody else that evening for OWI?
No.
So this would have been the only arrest that you made that evening?
So, yes.
Now, at the point that you first saw his vehicle, you immediately turned on your lights?
I left my position myself on Washington, caught up in the turnaround.
Okay. Turned your lights on indicating to Mr. Montague that he needs to stop, is that fair?
Yes.
And he responded to that request, correct?
Yes.
He pulled to the shoulder?
Right, yes.
Okay, he didn't park his vehicle in a fashion that he blocked any other traffic, anything like that?
No.
So from your perspective, then your observation that he otherwise legally parked the vehicle, is that correct?
Yes, it is.
The arrest was alleged to have occurred in the month of December, is that correct?
Yes.
The weather then would be appropriate for December in Michigan?
Yes.
Recall exactly what the temperature was?
I know it's cold, I believe it was actually snow.
Okay. Do you recall, was there snow on the roadway? And with the exception of the speeding and the unlawful passing, did you observe any other?
I'm at a hotel in Cleveland.
All right, well, Mr. Fortunato, do you know if there are some disposition documents?
Your Honor, it sounds like there may be some completed, but I think he needs to get them to me. They may be with a different prosecutor.
Okay,
So
I'm gonna,
perhaps.
I'll pass over on this case until those documents are ready.
Thank you. Thank you.
But I do see some for Brandon Bach. I just lost Mr. Kale.
Never a good thing now. Because you could do jail time, you understand?
Yes, Your Honor.
Okay. I'm gonna refer it over to the PD's office, but this is my stern talking, if you will, about making sure you get yourself on track, because I don't want to have to put you in jail. Okay?
Yes.
All right.
Friends, if you are listening, not watching, please vote and check the trial that I said I'm thinking of if we do a trial. There's only 3 votes so far.
So make sure you complete the anger management course in lieu of the community service course, and complete the MAD victim impact panel, and continue with the rest of the terms of your probation, including your community service and your monthly reporting and your testing. Okay?
Yes, Your Honor.
Any questions about any of that?
No, ma'am.
Okay. All right. And if you have any more questions, you can contact your probation agent.
Yes.
That's Ms. Straub. You have her contact.
We'll keep in contact with her.
Okay. All right. Thank you. You're all set. Have a good day. All right.
You too.
Bye-bye. Make sure I put the date in there. So, I did. Oh, I didn't. That's today's date. Ms. Jones' court date is going to be October 21st, 2024 at 10 o'clock a.m. And I'm referring it to the appointing authority in case we have issues. Lane Township versus Asante Crockett, case number 20T00512.
Paul Barnett on behalf of the township.
Assistant Public Defender Davia Lieb on behalf of Mr. Crockett. Mr. Crockett, can you state your name, sir?
Mr. Asante Crockett, please unmute your device, turn on your screen, and state your name.
Asante Crockett.
Thank you. Please turn on your screen, sir. All right, we're here for payment in this matter. It looks like Mr. Crockett, as of the July 15th date, the day this report was ran, had not made a payment since April of 2024. Have there been any payments?
There have not, Your Honor. Mr. Crockett has explained to me that he has been out of work due to an injury for the past few months. However, he has now been able to receive some back pay for that, and he does intend to make a payment today. And he's going to be able to continue to make payments on the 22nd going forward.
All right, I'm gonna put this over to August 5th and see if he's made a payment.
Thank you.
Good question. My cousin girlfriend.
Mr. Drummer, please mute your device. Okay, August 5th, 2024 at 10 o'clock a.m. Bond is continued. I'm sorry. I'll just see you back here. There's no bond on this. We'll see. Mr. Crockett's like, what? We'll see you on August 5th, Mr. Crockett. Make sure you make that payment, okay? State of Michigan versus Portia Elledge, case number 23 FB 1101.
Richard McDuffie for the people.
Assistant Public Defender Davila before Ms. Elledge.
Okay, 1 minute. I set up the portal to Recovery Addict and he's ended, and I meant to do it to my other stream so that people get the notification. So here we go. Everyone hang tight. We're not ending. We're just going to a different stream.